Yes.
Lordship. Lordship, I beg to mention a writ appeals for urgent listing in
Why?
municipal.
What is the urgency?
Sir, in this matter, a single bench passed in judgment on 22/12/2022 in favor of the highest bidder. But the problem is that the settlement is for 8 months, it's beyond the financial year. So kindly list the matter.
Beyond the
Financial year, which end on 31st.
what is your problem? What is your problem?
It's,
What is your problem?
sir, I'm for the Jorhat Municipality Board, and this is beyond the financial year. Lord.
Correct. Who has settled it?
Yes, Lord.
Who has settled?
It's a single bank.
No. Who is the authority who settled the tender?
Who settled the tender?
Jorhat Municipality Board has to settle it in favor of the highest bidder, as
then-
per the order of the single bench.
So what is the problem?
It is beyond the financial year, Lordship.
So what is the problem? If it is settled beyond, what will happen to? Will Jorhat break down?
No,
Will Jorhat go to Brahmaputra Nadi? What will
The problem
happen?
will be the next once the next financial year will start, there will be fresh NIT.
So you will see that what is the urgency. Next financial year will start after a few months. Today is January.
Kindly list the matter.
It will be listed, don't worry. There is nothing, no hurry. Ambulance is not required. Yes, it'll come up. You have filed an appeal, it'll come up. It'll come up in due course. If it may come up tomorrow also, day after tomorrow also, but then we are not making any order from us. It'll come up. Yes. Yes.
Please, Your Lordship. I beg to mention item 9 may come up to 3 weeks pallet.
Why? What happened?
I have asked my client to bring any paper is there.
Why you are not satisfied with the paper which you have filed? With appeal?
No, we have filed it. Earlier it was already notice was issued, madam, and now there is objection from my friend. That's why we want to highlight anything, new things are there.
Okay. Mr. Bish. Anyway, the matter will come up, all those matters, because these are all effective orders. Okay, we'll just mere, yes, it will come up. You can ask some junior to remain. Yes. Next. Follow up.
Yeah, please, Your Lordship.
Yes.
Lordship, I beg to mention item 10 of the daily list.
Please wait.
Lordship, in this matter, we are supposed to file our IA, but we could not collect the signature of the petitioner.
Item number 10. But item number 10, no? Hearing.
Contempt matter.
Yes, Lordship.
Contempt matter. We will come up, don't worry. We make an app. Yes. Yes.
But I beg to mention and PIL for motion on Monday.
What is that? What is the urgency?
Lordship, it's a scheme for digging a pond, Lordship, in the entire India. Therefore, it was done.
To scheme for
Digging pond,
digging pond.
Digging pond. It is done in the wrong place. It is not done in the place where it was foundation was laid, Lordship. Now it is done besides a river. And if it is done there, it will create a havoc in the flood situation, flood season, Lordship.
Who told you? Who told you?
Because before initiating the scheme, there is a feasibility report. Feasibility report is not done in this. So we are not opposed to the scheme, but it is done in the wrong place. That is just beside the river, Lordship. There are gazing fields, paddy fields, Lordship, everything. If it is done there,
anyway, it will come up. You have filed it.
Yesterday.
Okay, it will come up. Once you have filed, it will come up. Yes. Next.
Yeah, please, Your Lordship. My lord, I beg to mention for listing in the writ appeal, my lord. The method
You have filed it.
My lord.
It will come up.
My lord.
If your see any appeal file not coming up, let us know. Otherwise, don't mention. It will come up.
My
It doesn't require any order from us. It will be passed through. It will be yes. Yes.
Lordship, it's a matrimonial appeal, which we have filed an affidavit yesterday, Your Lordship. Lordship, kindly list the matter for tomorrow, Lordship, because if it is not listed, the respondent husband may marry another girl anytime.
Anytime.
Yes, your lordship.
How do you know anytime?
Yes, lordship, it has been informed by the applicant wife.
Applicant wife.
Yes, lordship.
He has already chosen the woman also.
Yes, lordship.
Oh, very urgent.
Yes, lordship.
Okay then. But suppose if he gets married today, then we can't help it.
Lordship, that's why kindly leave it because it's
Huh?
urgent. It's
Tomorrow?
urgent, your lordship.
Tomorrow.
Yes, lordship.
Okay. Tomorrow.
Obliged.
Hmm.
Lordship, I need to mention the item number 13. Because the guest counsel Mrs. M. Dev out of state.
You make a mention.
And
When
the
it is
other
called out, when it is called out, you make a mention, okay? Or you want to go out somewhere.
Okay.
Huh? You will be there. Yes.
Daily list for admission 1 to 5.
What is this? 1 to 5? APDCL. Assam APDCL. Yes, what is this APDCL? Why you have filed this appeal?
Actually, we had filed this appeal.
Huh.
There was a tender process which we had initiated
Yes,
for installation of solar panels.
yes,
Now this, the opposite side party had participated in a tender.
yes.
They were the successful bidder. They raised some grievances regarding the letter of award. One of the grievances was that, one of the problems which they had was that there was a change in the payment terms. On that basis, they filed a writ petition. They did not tender their unconditional acceptance. We terminated their letter of award. They filed a writ petition. During the pendency of the writ petition, the earnest money was also forfeited, and we initiated a fresh tender process, which has been completed. Now, what the learned single judge held was, your lordship, that since there was a change in the payment terms, we could not have forfeited the earnest money, and we are directed to refund the earnest money. We are in appeal against that, your lordship.
You want to keep that money with you.
Just one aspect, your lordship. Otherwise, almost everything has been extensively dealt with by the learned single judge. Only one aspect of the matter I'll place before your
Yes,
lordship.
what is that?
Though we have filed our written arguments, lordship,
What is wrong with the learned single judge?
yes. One aspect of the matter which, according to us, was perhaps not considered in its proper perspective, was that the tender document mandated, your lordship, that once a letter of award is issued, then the contract has to be executed within 7 days.
Hmm.
Now, the grievance projected in the writ petition was that there was a change in the payment schedule, due to which they could not tender their acceptance. Now, if I may just take your lordship to the communication that they issued to us upon issuance of the letter of award. Just that communication, your lordship, which is at page number 191, your lordship. Now, the letter of award was issued on 12/11/2021. So the period of 7 days would have expired on 19/11/2021, your lordship.
Sorry, it was issued on
The letter of award was issued on 12/11/2021.
12/11.
So the period of 7 days would have expired on 19/11, your lordship.
Now, what is this 2020,
The letter of award is at page number 188, your lordship.
198? Okay. Oh, hard heart fix. Okay. You don't want to start the day with a hard heart matter. You wait for some time. We'll see, yeah? I don't want to have a traffic jam. Yes, you wait for some
Very
time,
good.
we'll take it up.
Item number 6 and 7.
Upen,
May I please, Madam?
yes.
Madam, the matter pertains to fixation of pay of teachers, graduate teachers in LP schools.
2019, why it is coming up for today? What for?
Madam, it was
What
fixed,
is it?
Madam had heard it also on the last occasion. Unfortunately, I was not here, Madam. Madam had heard it also. And the government was also here. Today, I don't find anybody, man. What had happened here was,
No,
my
no,
lord,
no,
the
no.
pay commission gave us a particular scale of pay. Then, my lord, the government on its own, through an anomaly commission,
But who is
reduced
the
it.
other side? Why all your energy will go waste?
The Lordship, Mr. B. Gogo is to
See?
appear for this matter. He's on legs in court 19. Pass over the matter for the time being.
So all your energy, vocal energy will go down the drain. There's no point.
Type the-
He will say, I don't know what Mr. Nair has submitted.
Type the, Madam. My lord will have it all.
Next.
Time being. Item number 8. Allowed in this case, some
time which more needed for instruction, my lord. And query has been made by the honorable court, my lord, whether the suspension can be converted into compulsory retirement.
Suspension.
Yes, my lord. For
Suspension?
delay and negligence, my lord.
No, suspension.
Removal, my lord.
Query has,
Well,
or removal.
you have removed, why did you remove him?
He has, my lord, approached this honorable court after 6 years.
Whatever it is, what is the ground of removal? Why he was removed from service? What did he do? What mischief he committed?
He
What
was
misconduct? What is the
unauthorized
misconduct?
absence.
Huh?
Unauthorized.
For how many days?
6.
How many days you are absent? Constable.
Mondays.
More than a year. My lord,
How many days you are absent? How many days?
my lord, the petitioner, my lord, he went for casual leave for 10 days, my lord, but he could not return on time because he started suffering from neurological disorder.
So thereafter, how many?
My
days
lord,
you were removed?
around 6 months, my lord. He
6
tried to
months.
communicate with
Then
the
you
department.
became well.
Yes, my lord, and my lord, he comes from
How
very,
did you become well?
my lord, neurological disorder, my
How
lord.
did you become well?
My lord,
What treatment you undertook?
my lord, he can't. He comes from very poor background, my
We
lord.
are not on that. Whether you are poor or rich, once you suffer from a neurological, we are interested because there is a good source of treatment for so many people who suffer from neurological problem. 6 months you suffer from neurological problem.
My
And
lord,
you
he's still
restore-
suffering, my lord.
He's still suffering.
He's still suffering, my lord.
Okay. Then you return to service. How
Yes.
many years you have served before you suffer?
My lord, for around 2 to 3 decades, my lord.
Oh,
For many years, my
oh,
lord.
no, don't say 2 to 3 decades. You may 2 to 3 decades, 20 decades, 2 decades mean 20 years, 3 decades mean 30 years. A
My
lot
lord,
of
more than
difference.
20 years, my
Huh?
lord. More than 20 years.
More than 20 years.
Yes, my lord.
More than 20 years can be 21 and 29 also. You have to be more specific,
Yes,
madam.
my lord,
Because 21 and 29 makes a lot of difference.
my lord, to be specific, my lord. My lord, 28 years, my lord.
28 years, see?
Yes,
Now you are
madam.
nearing 30.
Yes,
See?
my lord.
So more and more the court will be inclined towards you. 28 years.
Yes, my lord.
28 years. And what is the order of, and what did Lana Single J say?
My lord, page 52.
Page 52.
If your lordship come to page 54, para number 5.
What did Lana Single J say?
Para number 5, 54 page.
What is the direction of the Lana Single Judge?
My lord, he was rejected on the ground of delay in lashes and acquiescence, my lord.
DN latches.
Yes, my lord.
DN latches. And a person gets a pension after 20 years of service.
So, my lord, can it be after 2
What
weeks?
can it be?
Yeah.
Let it be finished off.
Please, Lord, after 2 weeks, in the meantime, some
What after 2
instruction.
weeks? What instruction you will receive?
My lord, whether it
You're
is
not going to get any instruction. You have been asked for instruction long time back in last year.
only 1
Last
week.
year.
Let it come on next week, my lord. Let it be on.
Why are withholding us from
But
exercising
there
our
is
power?
some urgency on
Huh?
our part, my lord.
Next
This
week, my
fellow,
lord.
he'll go more mad. After 1 week, he may deteriorate.
Only 1 week, my lord. He had
Monday.
waited for 6 years, my lord.
Monday.
Yes, my lord.
1 week will make a
At least
difference.
on Monday.
Wednesday, my lord.
Wednesday.
If it on Monday.
It is Monday.
What difference does
You
it
see,
make by 2 more days?
Nothing will happen.
You obtain your instructions.
Poor fellow, he needs your assistance.
Madam.
He is not fully recovered also.
But no documents has been annexed in the writ
Doesn't
petition.
matter. You have all the record with him. He is a constable. You find out what is there. What is the big deal? He's a constable, 20 years of service he has rendered. And one fine morning, because his mind is not well.
2014 challenge.
Doesn't matter. But at least for the thing which has served, 28 years, he has stopped so many thefts taken place. Isn't it? He was on duty, either in Guwahati High Court or wherever it is, railway station. He has done some duty, prevented some crime, being committed. 20 years service will go down the drain. Monday.
Monday, madam.
Monday. 6 and 7, I said.
6 and 7.
Six and
My lord.
seven. What is 6 and 7?
My lord, this is with regard to that pay scale authorized to the graduate teachers in LP school. Now, what had happened was, my lord, just a small background, my lord.
Anyway, what to do today? This you are getting some salary.
We are getting
Very good. Then we'll take it up some other time.
not the proper, proper salary we are not getting.
Oh, you'll get proper. Everything you'll get. Don't worry.
Lordship is having it after 10 days or 2 weeks, man.
This
What's-
after 2 weeks.
After 2 weeks.
Lordship.
Next,
Item number 9.
Sambharu. Somebody wanted some time. Yes,
Yes,
you
but
wanted
if
some
your
time.
lordship is kind enough, otherwise I have to do it.
Notice was issued.
Yes,
Respondent. Not came. Talukdar, respondent 5. Request, matter is adjourned. Oh, matter has been adjourned because of the government.
Yes,
Not
but Honorable, didn't Chief Justice request, I directed them to consider the matter. But my
Who
learned friend
consider?
said they cannot consider it.
What is to be considered? Tell us.
My lord, what happened, my lord?
Who are you?
2 names were dropped by mistake by
You-
executive
you-
engineer,
you-
while
you-
their
you are
names
serving
were
us.
recommended for the regularization, master work,
Ah.
as per the scheme of the government of Assam.
Sorry.
My lord, I take your lordship to kindly come to this page, my lord.
What are you serving? What is your problem? Tell us.
Yes, I'm serving, my lord. Now, my lord, while the regulation partner was, my lord, page 46, kindly come to me. Page 46.
Your plea is that others have been regularized. You should have been also.
No, they have admitted their mistake by executive engineer, by mistake,
And
but it is still pending, my lord.
just a minute. Then you are the one who is coming in appeal.
Yes, yes.
Why? What is
Because
wrong with
Learned
you?
single judge has rejected because of delay.
What delay? How many
But-
delay? How many days?
That they said that you have come very lately
How
now.
many days? How many years?
Well, it was the scheme of 2005.
And then
Then I have come in 2020, 22.
after 15 years.
But
Somebody
there was
told
a
you.
regular correspondent. Even authority has correspondent. They do it, they are not doing it, my high authority.
Is it so? You have
Yes,
been also
yes.
giving false hope, Mr. Government. This poor fellow, you have been giving false hope.
No,
Proper hope.
Lordship, no.
Then
It is not our fault, it is the executive engineer who
it was-
admitted the mistake.
it was that.
Page 46, my lord.
Page 46.
Yes. With reference to the above, I have the honor to intimate you that true number of masteral workers of
Are you still
the.
serving?
Yes,
Are you still serving?
yes.
Is the scheme gone or still off?
No, I am still working.
No, is the scheme still operative or
No,
not?
he still is operative, my lord, definitely
The
operative.
scheme is still there.
Yes.
Then why you consider now?
Lordship,
Even if he has missed 15 years before, if he is eligible, consider him.
Lordship, the document that he has shown is of 2005.
Whatever it is, examine
Even
date,
if it is wrong, Lordship, he
whatever
ought to have
examine
come
date,
in
you
time.
find out his document, his.
Lordship, may kindly turn over to page 40. His age today is 60 years, Lordship.
Huh? And how long he can continue?
No, by mistake, I have written a secret.
By mistake,
Page,
Lordship,
page,
wait,
page,
31st December
How he
2020, I have
can say
written.
it now
Page,
that
page number.
40, Lordship, in the affidavit, Lordship. His
That was
age is 60 years, Lordship.
that I have explained before this Learned Division Bank. The by mistake, the date was given wrongly.
Anyway.
But I am still working by 31st December.
You consider what hearing? Why?
No,
What
Lordship,
is
may kindly
you
say-
consider if it is found eligible?
Even if it's a mistake of the respondent,
You
it
find
was
out-
in
you find out
2005.
whether he write
He didn't
100 years or
approach in
200
time,
years, you
Lordship.
find out from your record.
Lordship,
You
he
go by the
didn't
record.
approach in time, and today he himself has swearing that his age is 60
No,
years.
but whose mistake was it to leave their names?
Lordship,
on the
that
list.
has to be, he ought to have come, he slept over his right, Lordship.
Oh. Whose duty is it to ensure?
Lordship,
Your
let me assume, Lordship, since it was
No, your
dismissed on the first
documents,
day, Lordship.
your correspondences are very clear that the department is conscious.
Lordship, it was in
That the names were
2005, Lordship, since it was disposed of in the first day, Lordship, that I have to, why it was left with the further reason, but Lordship may kindly see he approached this court after 17 years.
No, but your correspondence is up to
He
2019.
slept over his right,
Mr.
Lordship.
Your
Even if you have
correspondence-
slept at a time, if the scheme is still continuing, is the scheme still continuing or not? If you say that the scheme is no more in existence, then of course we can't
No,
help it.
Lordship,
But if the scheme is still there and see his age, you verify from record, if he's eligible, consider it. That's what we can, we are not going to say that you regularize him. You say consider. We want to
Lordship, then
close
in
this
that
chapter.
case,
Mr. Hart,
Lordship-
Mr. Lane, counsel.
no,
for the-
Lordship.
Sorry, we are disposing of, do whatever you want. Hart, we don't want to keep this kind of matters pending in this court. Sorry.
Yes, Michael.
Hart, Mr. Lane, counsel for the appeal, House Lane County. The present appeal has been preferred against the order dated so-and-so, passing so-and-so, page 2021. The Lane single judge dismissed the claim of the regulation of the petitioner on the ground of delay. Full stop. It has been submitted by Lane counsel for the respondent, and apart from the delay, the petition is overaged, and as such, the same cannot be the same cannot be considered. On the other hand, Mr. Lane counsel for the appellant submits that the petitioner, the appellant had given his age wrongly as 60, though he is younger than that, be it as it may. When asked by Mr. Lane counsel for the respondent submits that though the scheme is still in existence, the plea of the petitioner can be considered on the ground of delay as well as that overage. Having heard the Lane counsel party view of the view that if the petitioner, full stop, next paragraph, the ground for we have gone to the order passed by the Lane single judge. It appears that the petitioner has approached this court for a direction to respond authorities considering regularization on a plea that some other workers similarly situated as him had been regularized. However, his case was not considered due to mistake on the part of the authorities in not considering his case. Full stop. We do not wish to go into all these factual aspects at this stage. In as much as we find that the writ petition was disposed of without affording the state government of opportunity to file the affidavit. But if a person has rendered service as master role for a long period of time, and if the petitioner is writ petitioner appellant is eligible for consideration regulation in the scheme, the authorities are under bounded duty to do the same. Accordingly, we direct that the case with the appellant will be considered by responsible authorities for regularization, provided he is still eligible for regularization under the scheme, irrespective of his delay in approaching the court in filing a writ petition, which we consider not to be relevant if the still continues and he is eligible to be considered. So, however, as to whether he is eligible or not, that is an exercise to be undertaken by authorities concerned by taking into consideration all the relevant documents, oblique records, full stop. With the above observation, we allow this appeal by interfering with setting aside the impugn order to the so-and-so.
Deep problem.
Next,
For orders, item 10.
what is this item number 10?
Yeah, please, your lordship. Lordship, in this matter, we are praying for time to file our implement application.
Okay, you want to file impugn? Okay. List of the so-and-so for, you are for whom?
I'm for the petitioner,
Okay. You are not answer for
appearing
impugn.
on behalf of the ghost.
Okay, Mr. so-and-so pays for some time to implement the concerned official. Okay, please play the law. List of the 3 weeks. Yes, next.
Deeply obliged. Item number 11.
Monsa Ali Sheikh. Yes, Monsar Ali, yes. Yes.
Lordship, I'd like to withdraw the appeal, Lordship.
Why, what happened?
Lordship, the appellants are no longer interested to place the matter. We have also communicated several times,
Okay,
Lordship.
no problem. Hard means
8 Alukdar, Lordship.
8 Alugolani counsel for the appellant, who submits that she has received instructions not to pursue this appeal in view of the submission when the present appeal is closed on withdrawal. Yes.
Much obliged, sir.
Item number 12.
In this case,
Yes,
the
yes.
record was called for from the office of the deputy commissioner.
Item number 12.
Let us not have come out.
Okay. This after 2 weeks?
My lord.
This after 2 weeks? I want to enable the authorities to produce the relevant records, huh? Records. Okay. Next, item number
Item 14.
contempt. Bokul Kumar, why it is list fixed today? Bokul.
Sorry, item 13.
Item number 13, yes, Madhu Surana. What happened to Madhu Surana? IA. What is this for? IA for what?
Lordship,
Yes, what is this
Yeah.
matter about?
Lordship, I am not in the case, but the learned council request to I
Requested to adjourn.
adjourn the matter.
Just a minute. What is this IA for? Limitation of 122 days. Limitation. Respondents have been some notice of what? Office note. The revision notice was issued on 16 by your investment notice has been received. Notice have been received by employees as a service company as on 16. Seeking for delay, issue notice response 8 to 16 and 18 by register post. The matter is 2020, Mr. No one appears for the petitioner, Ms. Dev for the applicant. Regarding what matter? What is respondent 6 to 8?
6 to 8, my lord. 6 is the OC of the Patasel Ambari. 7 is the Panbazar police station.
No, this
8 is the
application for
inspector.
delay, conveyance applicant to take service around meaning 6 to 8 and 18 by restart post. Now 16 is complete. About 6 and about 8 to 15, what will happen to them? What will happen? In respect to respondent 13.
13 is one mono school.
In respect to have entered. Oh, in respect to respondent 8, 10 and 15. Learned counsel has appearance. Who is the conducting counsel who on?
I don't.
No, we have mentioned on behalf, whose behalf?
M. Dev,
Where is the M there?
Mrs. M. Dev.
I think Manjuli Dev, my lord. If I'm
Manjuli
not
Dev.
wrong, Manjuli Dev.
Where is she? The matter is pending for last 20 years. 20, the last 20, from 20 onwards, matter is pending. If you are not interested, we will close it. Why keep this matter? There are so many important cases to do. If you are not interested, don't do it. We will close it. You file a case, don't take steps. Where is she? The M. Dev.
I don't know.
You don't know.
Who instructed you?
Who instructed you?
My senior,
Who is your senior?
Rajiv Chakravarti.
Huh?
Rajiv Chakravarti.
Rajiv?
Chakravarti.
Rajiv Chakravarti is your party
No,
here.
Lordship.
Huh?
He is not in the matter.
He know in the matter. So somebody else is instructing you to appear in this case.
Where is he? Where is your senior?
Rajiv Chakraborty, he is not come.
My lord, I think he has fractured his leg. Alpation nahi. Alpation nahi. Alpo nahi. Yes, as I am.
Okay, list up the 2 weeks, huh? What is your name?
Ibdudina.
On the Prime Minister during that, with the matter of the 2 weeks. Okay, yes, next week.
Item number 14 and 15.
Why these content matter?
Worship, I'm entitled to minimum pay scale. as per-
Oh, but who is the other side? Minimum pay scale.
Yes, my
So
lord.
who is anybody who preparing for the respondent at the request of Dapta? Chalia. Where is Mr. Chalia? Chalia name is mentioned. Yes, names are there. Mr. D. Saika, B. Gogo, P. Nayak, Chalia. So many ukils. Where are those ukils? 4 ukils.
Yes, ma'am.
Where are they? Huh? Yeah, otherwise we'll ask the personal appearance. If the lawyers do not turn up, we'll ask the person to appear in person. That's all. Simple. Wait for some call. Otherwise, if the lawyers do not turn up, we'll call the person to appear in person. That's all. You call the lawyer. We cannot do like this. Sorry. If you don't take interest, we'll call the person in person.
Mr. Das, you can inform the council,
You know
Yes,
there
ma'am.
are four persons are named.
keeping it aside for the time being.
Yes, yes.
These are serious matters in the court.
Item number 16.
Shankar Biswas, what is this?
Lots of matrimonial appeal to other side, the service is complete, lots of other
Okay.
side has appeared. So it may come up for admission here. It is yet to be admitted also.
Not to admitted. Yes, who is for the other side?
Name is shown lots of in the past list.
Who is he? Then we'll admit. And Mr.
Didas.
And a counsel for the known appear for the respondent. Now, why is that? Then there is some notice. How do you say some notice?
Lots of, they have filed a power lots of.
Power. Why is it? You don't see the power.
Okay, on previous occasion, they appeared lots of. Probably name is not shown, but they appear.
Nothing mentioned in the report. LCR notice has been issued on behalf of respondent by memo.
1612 office notice.
What is that?
Senate council appear on
Let the counsel appear on behalf of respondent filing a work. Okay. We'll admit them. And Mr. Lana known appears to respondent in spite of service of notice. Appeal is admitted. All for the records. Records have been received or what?
A report probably has been received.
And what is the IA? No IA.
No, I.
Okay. Records. Then your file is appeal like why? What is the problem?
Lots of the husband is before your lots.
What was the order passed with the learned family court?
The divorce has been declined. Divorce
Petition filed by seeking divorce. Is already dismissed.
Dismissed.
So you wanted divorce.
Lots.
So have been dismissed. And you want to stay with your wife. Okay. I will admit you will hear.
Lots.
Okay. Since the records have been received, the matter will be set for hearing. Yes, next.
Item number 17.
Sanjeev Bora. Yes, Sanjeev Bora. Yes, what is this?
Today was
I for what?
IFR for duration of
How
delay.
many days delay?
It is a delay of 2000 days, more than 2000 days,
2033 days.
2033 days.
Why there so much of delay?
Because our Guwahati legal aid
Sorry?
committee,
No, who is for the, are you, this respondent is printed or what? You are there.
Yes.
they are supposed to file the affidavit in opposition today.
Lots of today, lots of the reasons given, lots of in paragraph 2. I can't say much. Even then there is a delay. It was allotted to someone else.
Unfortunately, judgment passed. You know about judgment free learned counsel, he was able to file appeal and ask him to arrange funds. He doesn't have funds, then what to do? What are you? What are you doing, Mr. Bora?
I am doing nothing. I am in penury.
Huh?
I have been pelluted. I have doing nothing
No,
actually.
no, you are serving as what earlier?
Earlier, I was serving as a temporary in the office of PWD.
He doesn't have money. He doesn't have money to approach this court, therefore he didn't appear.
Yes,
Now he has been given a
Lordship,
legal aid counsel.
Yes,
You are a legal aid counsel.
I have the legal aid card.
So
Lordship, that's why I
so how much?
pointed out paragraph two.
We will
Lordship,
admit
I
then
can-
what is the in the appeal and appeal. Why you have filed the appeal? What is the ground? What is why you have filed the appeal? What is your impugn order?
Lordship, a single judgment was there in 2015. That
Sorry?
I would have gotten 4 marks as grace marks in the interview. I was not given. That is the ground of the appeal. Lordship. It is a comedy of errors, Lordship, and comedy of doing nothing. The department made a mistake. The Guwahati Legal Aid Services Committee sat over it from 2015.
Response number 10. You have challenged the appointment of response number 10.
Yes, Lordship.
Sanjeev Bora. You also applied for what post? LDC? LDA?
LDA, Lordship. I worked there for 4 years.
Now, the problem is that don't expect this court to
Lordship, it is a
interfere
matter
with
of,
the appointment of response number 10 after 15 years. Don't
Lordship,
expect that.
let the matter be admitted.
Now, admit for what? If you don't interfere with his response number 10, what will you do?
I will,
We are not inclined to interfere with response number 10 after 15 years of service.
Lordship,
LDA.
it is a mistake of both the government side and the legal aid.
No,
of
on
what
merit, please tell us on merit.
So he can be appointed, he will only work as a, even if he is appointed today, he is 52. He will be working as a daily wage labor. He will not get pension, no benefits, nothing. But let him get the benefit of justice. That
What
my
is
view.
justice? What is justice? You
That
said benefit of
he should
justice.
have been-
I don't know what is justice. Tell us what is justice. It's
He
not
should have
defined
been
anywhere.
considered.
Huh?
He should have been given 4 marks. That 4 marks should not have been denied.
Suppose if he is given, then what will happen?
He would have got the job.
Huh?
He would have got the job.
You will go to the job. You would have got the job. Now you are how many years? 50?
52, Lordship.
52.
Even hypothetically, I get the job. I will not be entitled to any pension or other benefits.
How do you say that that 4 marks was denied to you? On what basis?
That judgment failed to consider, single bench judgment failed to consider that I would be entitled for that 4 marks. Lordship, my simple prayer today is let the matter be admitted. And then let the process start. He should not be denied of the justice. It was no fault of his.
Respondent number 10 was placed in the first position above the petitioner in the second position. You are in the second position. Respondent number 1 was in first position. Alleging
Had
that
I been
selection was
given the 4
conducted without
marks, I would
giving
have
any
been in the
weightage
first
in
place.
terms of order of this court, number 5. And if you join his close form.
Lordship, there is a question of Article 14 of the Constitution involved. The critical matter of law for this honorable court to decide. Whether a man who should get weightage can be denied weightage the second time when he appeared successful. The last page of the single judge.
What is the order of the court which according to you, you are entitled to these marks, weightage marks?
I was denied these marks by the election 55 Lordship.
Page.
Page 55.
Page 58,
Sorry.
yes.
Sorry, Lordship.
You said you are entitled to additional marks, no?
I have entitled to additional marks which are
How? On what basis? By which other?
by
by
the
which
rule
order?
of the government.
Page 41. It's filed by him. Sanjeev Bora. You are Sanjeev Bora. Okay, we'll hear you. We'll hear you.
Lordship, I'll be
We'll
obliged.
condone this delay, this post.
Lordship, I'm asking because,
Okay.
This is a very interesting matter,
Okay.
Lordship.
Huh?
This is a very interesting matter.
Interesting
law.
matter. I don't know what is interesting or not interesting.
I
For us, every
I'll
case is,
submit before your Lordship.
okay, hard missed. Huh?
We better.
Every matter is either interesting or not interesting for us, same category. Or Mr.
D. Banerjee.
For the applicant, huh? The present application filed for condonation of delay not being seriously contested, delay on the ground of his poverty. On the ground of his lack of resources. And inability to approach his court in time. Due to his not being for not being able to engage a counsel. Being not seriously objectful counsel for the state is allowed. Application allowed. Let the connected read appeal be listed next week. When you are ready, when you come ready,
Lordship, any day.
huh?
Any day.
Next week, come next week fully prepared.
Lordship.
Next week, will be listed by rest. Huh? Yes. Yes, next.
I'm obliged, Lordship.
Item number 18.
Item number 18. Partho Sarthi Roy. Yes, Partho Sarthi.
Here we have challenged the impugned final order.
What is
of
this
the
IFOR?
order-
IFOR.
IA is for stay, my lord.
Huh?
Stay of the impugned order.
Stay of the impugned order. What is the impugned order?
Impugned order at page 41 to 46, my lord.
Page 41 to
46.
page 41. What is the direction given by the
Here, my lord. My lord, the
Constitutional
ground
Authority
of
directed to
challenge-
initiate a fresh process of settlement by Erin prescribed? And why you want the stay of this order?
Here, my lord,
Why you want the stay order? Tell us quickly.
My lord, there are two main grounds. One ground is that
Yes.
the writ petitioner did not have any local standing because he never participated in the process, my lord, tender process, my lord. He
Okay.
did not submit any tender.
Now, what is the
And,
present
secondly,
condition? Who is for the state? Madam, what is the present status
Lordship,
of this settlement? Fishery,
My lord, the writ
what is
petitioner
happening?
Lordship,
did
here,
not
Lordship,
challenge.
they have added, my name has been wrongly added, Lordship.
You have been wrongly added.
Added.
Doesn't matter. If you wrongly added, we will not hear you. Then who is for the state? Who is for the state?
I'm for the state lordship.
Huh?
I'm for the state lordship.
Fishery department.
Fishery, here's the fishery department.
No, Lordship, I'm not for the department, I'm corporation.
Fishery আমি করে
And fishery department.
Actually, Lordship, there is a misconception. They thought that the fishery, I have to give the reply. So they said they could not get any
Is they
instruction.
call fishery corporation also? What?
No, I'm for corporation.
Corporation of one.
Assam Fishery Development Corporation.
Oh, Assam Development.
They are under impression that I will give the I will take the instruction. So today Lordship made
Settlement is not by you.
not by me, Lordship,
But settled by the state.
department. So they were under impression that I will take the instruction.
Oh, I see.
Today Lordship made the date may be given, Lordship. He will
2 weeks
take
time.
2 weeks time. She will take the
There is
instruction.
a confusion among the fishes. Which fish will respond to you? And they were confused. Big fish or small fish? Corporation is a smaller fish. A to dangor fish. Dangor fish will do that.
So Lordship, my name may be strike out, Lordship, from the call.
We will not strike out anything. We'll see whether you are wrongly implemented or
No,
not.
no, in the cost title, my name is not there, Lordship.
Oh, in the course title is not there.
Not in
Oh, I
their
see.
cost title.
Okay. Then
Your
So,
my lord,
I'm,
the
I'm-
did not challenge the my lord tender.
I don't
notice,
know why
my
my name is there.
okay. It has been submitted by Mr.
P. Sharma.
P. Sharma that the Standing Council of the Assam Fishery
Development Corporation.
Corporation being not a party in the proceeding, comma, may not be shown, the name may not be reflected in the cause list.
Lordship, highly obliged.
According in your, you also agree to this,
Yes, my lord.
which is not disputed by Land Council for the applicant, read applicant also in view of the above. Let the name of the Standing Council AFDC be struck off from the cause list. Let it be shown by showing the name of Standing Council of Fishery Department,
Lordship, government of Assam.
Government of Assam.
Your Lordship.
Fishery Department is under government of Assam, Lordship.
You are doing not only fish but others also. Huh? So you're not in charge of fish only.
Lord.
Okay, because there's some department which are exclusive, no PWD like that.
Yes, Lordship, not exclusive, Lordship. It is within the domain of government, Lordship.
You should have especially for fish also. It's a very okay. Anyway, list next week. Okay, after 2 weeks. After 2 weeks.
My lord, after next week, my lord.
Yes, after 2 weeks.
A date may be fixed, my lord.
Directly is after 2 weeks.
2 weeks, Lordship.
2 weeks, 2 weeks, 2 weeks.
Let's take this. Highly obliged, Lordship.
22-2.
Then I can.
For hearing, item number 19 to 21.
This is a hearing day or what? This is a hearing day. Thursday. So what is to be heard from you?
Yes,
You have to hear you.
only IA. That day, your lordship agreed that because hearing your lordship express that day seems little remote. That your lordship be able to complete the hearing. So I requested that let the bail matter be considered. That's how it has come.
So you want to say that even if you are convicted later on, even if your appeal is dismissed later on, you should be allowed to go on bail now.
Let's put it a different way, if your lordship permit me. In Kashmir Singh, that's 1977. Your lordship may be aware. There it says that if the appeal is not disposed of in 5-6 years' time, and after 5-6 years, if this person is acquitted, who's going to return his days? I put it different way.
But
Because if
you are
my
not
appeal is dismissed, I'll go back to jail.
you are not an ordinary citizen. You disclaim yourself to be a citizen of this country, according to them. You disown this country.
No, they don't have a case. Your lordship has heard, give me 10 minutes, I will
According to the
explain.
respondents, you consider yourself to be a leader of an independent entity,
No,
not part of this country.
No, that's not correct. That's allegations only without any basis, without any substance. And I have taken your lordship has forgotten everything, I think. Let me just remind your lordship.
It is good also sometimes to forget things, because see, good memory
Yeah,
sometimes
you-
creates problem. So I am happy that I am having a very poor memory.
No,
So I am
your lordship,
forgetful is very good.
I have to refresh. Otherwise, your lordship will remember everything.
So if you refresh, you have to start from the beginning, A.
Yes, I will start with only 4 points. I will take not even 20 minutes. You just hear me. Kindly, the first thing.
That this lovely Devi knows about my status. They don't disclose to me also. She knows very much well about my status. She doesn't disclose also. What to do?
The time changes. When, say, before you crossed over this, we were also friends. But after that, there is a smoke screen. So therefore, they are also unable to tell your lordship, and your lordship is also unable to tell me because of the smoke screen.
So you can perceive certain things.
I understand. That's why I said,
That is why, that is the difficult, otherwise
my lord,
we would have,
my lord, I don't want to put your lordship in any difficulty.
that is the only thing.
I don't want to put your lordship in any difficulty, and I leave it to your lordship.
Can we then list it
I leave it to your lordship because
2 weeks, because see, I fully understand your concern, your own as a council also, we have full sympathy. But there are certain circumstances which ARD Chaudhary creates for us, making it very difficult to sometimes make any comment.
they are responsible for everything.
You can say whatever you want, continue, I have no. You just, yes. You don't know, you ask Devi, your assistant, what has transpired in these few months before you came.
One line from your lordship, the line was, is pregnant with consequences. I think it made me, I said, I'm leaving to your lordship because I don't want to be a hindrance for anything.
I don't want to speak much. You can see from my face, my brother also.
No, we understand. That's why I said, I'll leave it to your lordship. I'll leave it.
2 weeks, 2 weeks.
Not on my prayer, let it be on his
Correct.
prayer.
On the prayer of R.K. Dev Chaudhary, the matter stand adjourned. Yes, you are the one responsible for 2 weeks. Don't ask any more questions.
For hearing, item 32.
Sumande. What is Sumande? What is this Sumande? Anybody? What is this matter about? Naya, what is this appealing? Promotion? Promotion matter? Is it a promotion matter? A promotion matter? It is a promotion matter.
Regarding
Appellant is a manager law.
yes,
You are a bank, Punjab National Bank.
two advertisements.
And then
One
what happened?
advertisement for promotional and another advertisement for direct. Whether the present applicant before your lordship is not the applicant of the direct appointment matter, but he filed this case matter, challenging this
Direct recruitment.
notification matter. In first, in promotional matter, he got the post. He was number 6, but only 2 posts were vacant. There's 2 persons were appointed, and he was not appointed. Thereafter, after the result of the promotional result, he filed this writ application before the thing result.
But where is the counsel for the appellant? Where is he? Mr. R. Mr. Where is Mr. Nair? Where is Mr. Nair? Where is Mr. Nair? You can ask. Where is Mr. Nair? Is there any fixed quota or no?
No.
Then you must fix a quota. You can't keep on changing. There must be a quota, promotion and direct recruitment. The source of recruitment.
Actually, in direct appointment, there is no quota.
No, you can't. I can't say that this post is to be filled up by promotion unless you say that this is not can be filled up by quota. It was entirely for promotion.
Yeah.
Oh, that is your case.
And he is neither an applicant and he is not eligible also, my lord.
No, he can't, then he can't, they can, then in the promotional avenues, if it is a promotion quota, and what is he?
In promotion quota, my lord, he applied and he got he got selected. Thereafter, my lord, he was in number 6 position, but there are 2 posts vacant only. So he did not got the post, my lord. Then, my lord, he challenged neither he is an applicant to the direct appointment nor he is eligible.
But you said that there is no direct recruitment quota. Just now you said.
Direct appointment, my lord, there are 2. One is technical and another is general. My lord, he is law officer, my lord. He is a technical group.
So where
He
is this
cannot come to the direct.
where is this Mr. Nayar, Chetri, Sharma? Where are they? If they don't come, what do we do? Yes,
My pleasure, Mr. But my son is legs in the court number 19.
but nobody is there. Senior advocate is senior advocate. There may be some lawyer who is instructing him also.
And they pass over the matter for the time being.
What time being? We have nothing else to
I
do.
have no brief.
We can't just sit and keep on chatting in the courtroom. Wait for you.
May I call him?
Somebody who knows about the case, some instructing lawyer must be there. This is not a personal case of a senior counsel. He is engaged by instructing lawyer. We want to know the facts of the case. We don't want to keep matters pending like this. Our duty is to dispose of cases by hearing you. But if you don't allow us to hear us, then what do? We dispose it of simple manner, which is known to us. Mr. Counsel, please come to page 16 of the. No, not you. For a bank, PNB. Please come to page 16 of the memo of appeal. Page 16, annexure 1. Synopsis. Is it correct?
Yes, my lord.
The appellant is serving as a post of manager law scale 2. The next higher post is manager law scale 3. To be filled up by direct recruitment. And the promotion in the ratio of 50-50, is it correct? 50-50? To fill up the promotional post, there are 2 modes, seniority mode and the fast track mode.
That ratio is not correct, my lord. Ratio, it is their ratio.
It's 50-50 ratio.
50, no, my lord. No ratio.
No ratio.
In
But
promotional, my lord.
can you show the rule for appointment to the post of manager law?
Yes, my lord.
Show us the service rule.
So let's see. Come to page 45, my lord.
Page 45.
45.
Yes,
The
manager
second
law.
column is, my lord,
Serial number?
page 45.
Page for number 3. Serial
Serial
number
number
3.
3.
Senior manager law.
my lord. Now,
Graduate with
minimum
degree.
age is 28 years, maximum is 35 years.
Okay.
My lord, this petitioner is 37 years.
Doesn't matter. We'll go on that. Don't
Then
bother that. We'll
Your
ask.
lordship may be pleased to see
No,
the
but it
last,
doesn't mean for age and square.
last column is,
Correct. How it is filled up by promotion or by direct recruitment is not mentioned here.
no, he is not eligible, my lord.
Oh, again, we'll not come to that. Please. Where is it mentioned that this post of senior manager law is to be filled up by direct recruitment or by promotion? Where is it mentioned?
Direct for all, my lord. He also can apply, any other persons also can apply, my lord.
We are asking you
But
one thing and
here the experience is, my lord, minimum 7 years.
online.
He was appointed on 17, my lord. It is,
No. This is an advertisement, Mr. We are asking what the rule. What is the rule? What is the service rule? Recruitment rule for the post.
yes, my lord. That is the
This is a
technical.
recruitment. You are showing the advertisement.
Your lordship may be pleased to see the promotion policy
Please.
at page 62, my lord.
Human resources management, promotion policy. But this is promotion, okay? Is it about this post, particular post?
Yes, my lord, your lordship may be pleased to see page 66, my lord.
Page 66, yes,
Election process for MMG scale 2 to MMG scale 3.
yes.
That is for promotional, my lord. The vacancies of MMG scale 3 shall be filled up by
Correct, but then-
promotion.
correct, we are not on
MMG
that.
scale
This
2
is a
to
promotion policy. But what is the general policy that this much post will be filled up by direct recruitment and this much by promotion?
yes,
Where is it? Where is it?
that is not there, my
It
lord.
is not there. They have created 50-50. They have created 50-50. And what does the learned single just say then? What does the learned single just say?
At 128, my lord, page.
Now, this advertisement which you saw was a direct recruitment, isn't it? Because it was a, huh?
Yeah.
Then there also senior management, how many posts? 55 vacancies.
55.
Out of how many posts? We advertised 55 up to how many posts? How do you decide is 55? Why not 50? Why not 40? Why not 20? Why do you decide 55?
Totally 55, my lord.
Oh, again, don't say totally. Total 55, from where you got it? The post of senior management, manager law, in the PNB is how many, total, how many posts are there? Please tell us.
They
Arey,
divided,
you have
my lord.
advertised X number of posts.
Yeah.
This X number of posts is out of how many total posts that you are advertising?
Advertising is only for 55 posts.
Huh?
And advertisement is for 55 posts.
55 posts is equal to how in percentage? How much is the percentage in the cadre?
In direct, and there is no percentage, my lord. One is
What?
promotional, another is direct.
What is the strength of your cadre or law officers or law managers in the bank across the country?
One is promotional and another is direct.
How
Correct.
many posts? How many posts in total?
Total, my lord, according to the advertisement, 55.
No, in the bank.
You are not.
All over. It is all over India.
You're not answering the question. Question is, in the bank, what is the total number of posts? Are these the newly created posts?
No.
Then what is the strength of the cadre?
On that particular date, my lord, there are 55.
On that particular date, your authority decided will advertise 55. Okay. From where you got this 55? Is a newly created post.
Then I have to take instruction. my
What
lord.
instruction? You have to have certain norm. How much is that? Yes, Mr. Nair, what is your case?
My lord, my case is that they have, while distributing the posts for the various categories, my lord, with regard to the post of senior manager promotion, they limited it to, but the other categories, my lord, would see, they have given a larger number of posts. That's why, my lord, my promotion did not take place. Otherwise, I was through, my lord. I had cleared the.
So according to you, they have exceeded in advertising in the direct recruitment.
Direct recruits.
If they had kept more for
They will
promotion-
have to have a ratio, my lord, between both. They cannot have a
You
ratio.
cannot- Yeah, you cannot
that-
change your ratio.
For
Every day.
post A, we will have 10%. For post B, we will have 30%. That should be written down somewhere. That's the error, my lord, in the judgment of the honorable single judge.
See, what is this? What is the learned single judge say then? Why the learned single judge dismissed your
Lordship.
case? On what ground?
My lord would come to the paragraph.
But was the affidavit filed before the learned single judge?
Yes. Affidavit was there.
Okay. Anyway, let us see what the learned
My
single
lord.
judge.
My lord would have to come to page 130, my lord.
What is the learned single judge say?
Lordship.
130.
30,
130.
Lordship.
Let us
That,
see.
therein the thing starts.
Yes.
Before appreciating the arguments advanced by the learned counsel for the petitioner and the learned senior counsel for the respondents, it would be appropriate to deal with the case of so and so. It appears that the relevant service rule did have a ratio for direct recruit promotees, and in the said case, rules were amended in 1952. In that case, there arose a question whether the rules was discriminatory, and in that context, the Supreme Court India had examined the 1952 rules, and it was observed. Rule 4 states that prescribed minimum qualification for so and so. It reflects the rules, my lord. Thereafter, next page.
There are 6.
No, my lord, just about that quoted portion in the middle, my lord. We would like to, that judgment of the Supreme Court.
Yes.
We would like to suggest that the government for future years, the roster system should be adopted by framing an appropriate rule for working out the quota between the direct recruits and promotee, and a roster should be maintained indicating the order in which appointments are made by that.
Okay. In a matter that para 6, in the
matter of employment, the employer must have a free hand to decide how to recruit personnel for a particular post in absence of rules prescribing any ratio for such posts which are to be filled up. In this connection, the petitioner is not found to have any fundamental right to have the post of so-and-so to be filled up in a particular manner. The petitioner participated in the promotional exercise for filling up so-and-so on promotion. Therefore, it is seen that the petitioner does not have any grievance, that there is no scope for career advancement so-and-so. For remaining, he would stagnate in the post forever. It is not the case of the petitioner that by the promotion policy for so-and-so, which includes the post of so-and-so, which does not prescribe any ratio for filling up vacant posts.
Okay, Mr. Nair. Why did they say that the PNB they can fix their percentage according to the, is there any in
Nothing, my lord. If they have, they let them place that before your lordship, my lord. There is nothing. My lord would come to the distribution that was made.
Yes.
My lord, it was my categorical stand.
We want to know Punjab National Bank. We wanted from you how many posts are there in senior level of law?
57, my lord.
Huh?
57.
57.
57.
Across the country or only the?
All across the country.
Out of 57, how much?
2 were given for promotion and 55 were advertised.
Direct recruitment.
And there is nothing on record to show. My lord, if my senior can
Maybe they think that they will get a better law
Fine,
officer
my lord,
from
but they'll have
press
to have,
market.
fine,
And all these promotees, they don't know anything about law. They have now.
I'm doing the work, my lord. I'm in the system.
And they all perhaps would like to have all these fresh graduates from national law universities. That is why. Yes, Punjab National Bank. What is the policy? What is your policy? Out of this total, what is the total number of posts in law? What is it? Law?
50, sir. Manager law, my lord.
Manager law.
MMG scale 3, my lord.
Okay, senior manager law.
Senior manager law.
Senior manager law.
Lordship.
What is the total strength in your bank? And how much you want to fill up by promotion? How much you want to fill up by direct recruitment? What is your policy?
That was not, there is no fixed policy, my lord. Whenever any vacancy arises, my lord, it is given from the.
Sorry.
Whenever vacancy arises, my lord, at that time, particular time, my lord, there are 2 vacancies. So they were filled up. Others were left. And they can go to the direct appointment. Your lordship, in page 101, in my affidavit in opposition, it was said, my lord.
Yes.
101, my lord, in the middle portion.
Yes.
Para 4, my lord.
Yes.
In the middle portion. It is needless to say, are 2 different processes. The ratio of filling up the post through internal process, that is normal seniority channel, and merit come fast track channel, has been defined in promotion policy in the ratio of 40% to 60% and 60%.
Okay, we have gone through. Yes, Mr. Nair.
Lordship.
There is some judgment. Don't expect this court.
No, my lord. I'll
there is
place
some
it.
judgment.
I'll place it, my lord.
Is that in this matter, it is that they should not only judgment, there is also direction of the central government.
Lordship.
Where the RR is silent.
Lordship.
They say that they must determine the ratio.
Lordship.
Why is that judgment?
My lord, I
You are
can
arguing
place
your case.
the 167-2 AI 1967 Supreme Court 1427.
Nikalo.
1967, Supreme
my-
Court 1427. I think, my lord, it's available on record only. I placed that earlier in this.
Dongle, you have got the dongle, no?
It is, my lord, SG Jai Singh
Okay,
Dhani.
no problem, you can use it, dongle also. Dongle, you can use, no problem. You can bring dongle also.
The judgment that the honorable single judge had also relied upon, madam.
No, you continue, but in the meantime, we can bring the dongle.
Two 2019 1 SSC 1 2. COVID-19 1 SSC 1. It was 1992 supply 130.
But then, Mister, you are citing government having fixed the quota, cannot deviate. You are
No, my lord. My lord, we'll have para 14 there, my lord.
There are 14.
14, my lord. How that discretion has to be used, my lord. When there is no fixation, there is a discretion. How that discretion is to be used. In this context, it is important to emphasize that the absence of arbitrary power is the first essential of the rule of law.
Yes.
In this context, it is important to emphasize that the absence of arbitrary power is the first essential of the rule of law, upon which the whole constitutional system is based. In a system governed by law, rule of law, discretion when conferred upon executive authorities must be confined within.
Oh, Mister, okay, these are a very general discussion. About
Lordship,
in service
my lord wants that
jurisprudence,
specific.
There is a judgment already decided by the Supreme Court.
Yes.
Do you want
My
that?
lord, I'll have
Don't
it.
say
My
yes,
lord,
yes.
I'll place it tomorrow, my lord. I'll place it tomorrow, my lord. Somehow it missed out from my ear. I'll place it tomorrow, my lord. If these judgments were placed on the last date of hearing, my lord, I thought it was there on record. My lord, I'll place it tomorrow, my lord. Tomorrow itself. My lord.
And there are also direction by the government of India, if all this there, yes, wherever there is the silent, it should be fixed.
And there has to be a manner in fixing that, man. That's
Whatever
it.
matter, we are not on that. First of all, it must be fixed.
Hmm.
It should be. Where is that?
I'll place it tomorrow itself, man. Tomorrow itself. Man.
Tomorrow we'll forget.
No, my lord. That's why I'm not saying they are a longer date, my lord.
What longer date? Not praying for a longer date. Okay.
And here also in para 15, my lord, it said that there has to be a ratio fixed.
Para 15 is there? Where is it?
The para 15, my lord.
Should be adopted or framing.
We should say the future years so and so adopted by
Yes,
framing and working out the quota.
Yes.
I'll place those judgments.
Yes, Mr. Punjab. You have to fix date, ratio for direct recruit and the promoting. You cannot go ahead like this.
And Lordship would just take three figures.
That judgment was discussed in para 5 of the judgment itself, madam.
No, that para 14 was not discussed, madam. 15 was discussed.
No.
In
we are
para
not-
5,
we-
at page 130, madam.
My lord, there are three posts I'll identify before your lordship. Three posts. Senior manager credit, senior manager agriculture, and senior manager law. In senior manager credit, there were 65 vacant posts. 51 was given for recruitment, 14 was promotion. In agriculture, all the 30 posts for promotion. And in law, 2 plus 55.
Because they know your quality of your legal knowledge, that is why. We promote this legal, the kind of legal advice they will get, and they all cases are all failing in high courts and lower courts. So they want to have fresh, good one.
My lord, even if that was the stand, my lord, I would have accepted it. That is not the stand. That is also not even pleaded, not even indicated, my lord.
And if this appeal is allowed,
Lordship,
those 2 posts will also go.
Will also go.
it cannot.
Even
There is a
promotion
promotional avenue given, my lord. And the posts are kept reserved. It's not that the posts have been filled up, the posts have been kept reserved, my lord. And they did not get anybody from the 55 posts that they advertised, my lord. They did not get much, my lord. It was very limited. 10 or something could be filled up at the maximum, my lord.
Page 118 of your reply,
Lordship,
you had referred to some policy. Is it on the basis of some rules, regulations?
22, my lord, 22/5/2019, 2019 it should be, that is there at page 21, my lord. That's, my lord, with regard to the cutoff marks and all.
No. This is continuation of para 10. of your
Lordship,
reply
Lordship,
affidavit.
Lordship. Notification letter issued by the so-and-so directing,
Below, in the next page,
Lordship.
the last paragraph, you were referring to the fixation of quota by
Quota.
the regional banks.
Lordship,
There you say that there's a schedule where it shows that 10% by direct recruitment, 90% by promotion.
this is, my lord, for regional rural banks, my lord.
Okay.
It was there. It was for regional during the banks. Then I draw an analogy and say that, my lord, even if we go by that principle, 6 to 7 posts would be available for direct promotions.
But this is not in respect of your.
No, regional bank. That's why I did not press it.
Yes, Punjab National Bank, what is your case now? Your case is a dyno ratio. Are you required to keep the ratio, or you say that the ratio need not be kept? What is your stand? Para 4 of your affidavit, page 101.
In 101.
Since there is no such ratio,
Yeah.
there is no such rule. So if there is no rule, therefore it will all go for a promotion. How do you decide? Why not direct recruitment? How do you decide? Who decides? Toss. The manager sits, your general manager sits, and he takes a toss, whether it will be promotion or direct recruitment. Whoever wins, or is it direct recruitment? So you go for direct recruitment. If it's a promotion, go promote, or you consult some astrologer, which is good for the company. Oh, better. This time you recruit promotion by your promotion, then it will be good for your. How do you decide? How do you decide?
That is not there properly.
No, how, no. So what is your view on that? What should be done? What should be done?
It must have been decided because your paragraph 4 of the affidavit of the bank,
101.
you made a statement that normal seniority channel and merit
40 plus
fast track is 40-60.
Yeah.
So 40-60 of what? There must be a cater string defined somewhere.
of the
If
vacancies
you
that
could
come.
decide for vis-a-vis promotion that 40 should be the normal and this will be fast track 60 into 40. Why can't you decide also out of this say 57 posts, so much percentage will be by direct recruitment, so much by promotion?
It is not
It has not. So you do it, then we are allowing the appeal. Mr. Mr. You give those judgments.
I'll give it, my lord.
Otherwise, we will not sign the.
My lord, tomorrow morning I'll be giving it to him.
And we will not sign the order. Don't complain.
No, my lord.
Court has
No, I'll give it tomorrow morning itself.
We are not going to do.
No, my lord. I'll give it tomorrow morning itself.
Okay, Liko. And Mr. Ilken Lane Senekam assisted by Mr.
A Burman.
Also Mr. RK. PK Kolita. PK Kolita Lane Senekam assisted by Mr. RK Bolwa for the bank respondent. Na? The present appeal has been preferred against the, why is that single judge? Lane single.
Single judge order 128.
Against a judgment dated. Judgment order dated
26/2.
Passed the Lane single judge in WPC number 24, page number 128, by which the plea of the petitioner for fixing appellant for fixing a quota, a ratio for appointment for recruitment to the higher post of
Senior Manager Law Scale 3, my lord.
where is it? Page number?
My lord, the advertisement, my lord would find. That is at page 38, my lord.
Page 38. For the higher post of senior
Middle Management Scale 3, my lord.
to the higher post of
Senior Manager Law, Middle Management Grade
Senior
3.
Manager Law within bracket
MMG
scale 3
Lordship.
has been rejected by the rejected.
Yes,
Rejected on the ground that in absence of any rule prescribing any ratio in which such post is to be filled up, the petitioner appellant has no fundamental right or legal or fundamental right to seek any direction from the court to stop. Next paragraph. Before we examine the correctness of the view of the learned single judge, relevant facts may be noted. Next paragraph. The petitioner is presently serving in the post of manager law.
Manager Law. Middle Management Scale 2.
Scale 2. When was the promotion made?
My lord, it was advertised on, my lord, identified on 5/1/2019, my lord.
Is a promotion for promotion?
It is promotional matter.
You are not promoted because of lack of post, no?
Lack of post.
What is that promotional?
That exercise, my lord.
process?
That order, my lord, is not on record, only statements are there, my lord.
According to the petitioner, the respondent authorities issued a notice for promotion of the
Lordship.
manager law scale 2 to senior manager law scale 3 on 5/1/2019, in which the petitioner also participated. However, he could not get promoted as the promotional post was restricted only to two.
And I was serial number 6.
And the petitioner was serial number 6. Next paragraph. It is the case, however, in the meantime, soon thereafter, the petitioner found that the respondent authorities issued an advertisement for direct recruitment of technical
My lord,
officers to the
12 to-
higher post of senior manager law scale 3 on 12/2/2019.
Lordship.
Did you apply for this post?
No.
until and the said posts were filled up.
All the posts, no.
Was sought to be filled up by conducting the necessary recruitment process. We agree. It is the case of the petitioner that while the bank authorities did not apportion sufficient number of posts to be filled up by way of promotion, the respondent authorities sought to fill up the higher posts by a direct recruitment in a disproportionate manner, thus depriving the opportunity of the petitioner to get promotion to the higher post. Accordingly, the petitioner approached this court by filing the writ petition seeking for a direction to the respondent authorities to fix the ratio of the source of recruitment of direct and promotion at 50-50, so that the post of the higher post of senior manager law scale 3 can be equally apportioned to these two categories of sources of recruitment, and the petitioner who has already served for a long period in the bank as manager law scale 2 can have a legitimate expectation of being promoted to higher post. Next paragraph. The respondent bank authority in the said writ petition contested the writ petition and by filing an affidavit of opposition. In the affidavit of opposition, it has been clearly mentioned, admitted by the respondent bank authorities, that there is no rule fixing, there is no service rule in the bank fixing the ratio for appointment to the said higher post. Though there is a ratio as regards the promotion, as regards promotion, whereby the post which is to be filled up by a promotion has been categorized into two categories in the ratio of 40:60 under normal seniority channel and fast track channel is provided in the promotion policy. In this regard, we may refer to para 4 of the affidavit of opposition filed by the bank, in which the stand of the bank authorities is clearly discernible. Page 101, quote para 4. Next para. Before us, Mr. Kohli, the learned senior counsel for the bank, also has fairly admitted that there is no quota ratio or quota fixed for promotion of direct recruitment promotion as far as the higher post of senior manager law within bracket MMG scale 3 is concerned, and the bank proceeds to make recruitment fill up the post as in by way of direct recruitment or promotion as in vacancy arises. It has been also submitted that the petitioner could have applied for the said advertised post of senior manager law which have been advertised, but he being not eligible could not apply, and as such the bank authorities cannot be blamed if the petitioner is not eligible for applying for direct recruitment, which he otherwise is entitled to do so if he is eligible. And as such, it has been submitted, it cannot be said that any prejudice has been caused to him. We have heard learned counsel for the parties and also perused the records. We also have examined we have also considered the view of the learned single judge. The learned single judge, after considering the rival contentions of the parties, though parties took the view as stated in para 6 of the impugn order, that in the matter of employment, The employer must have a free hand to decide how to recruit personnel for a particular post of senior manager, low, page 131, scale 3, in the absence of rules prescribing a ratio in which such posts are to be filled up. In this connection, the learned single judge proceeded to observe that the petitioner is not found to have any fundamental right to have the post of senior manager, low, grade 3, to be filled up in a particular manner. And he had participated in a departmental promotion exercise for filling up the post of senior manager on promotion. Senior manager, grade 3 on senior manager, low, within bracket, grade 3 on promotion. Therefore, also accordingly, learned single judge proceeded to hold that it is seen that the petitioner does not have any grievance, that there is no scope for any career advancement avenue open to him. And he has no legal and fundamental right, and no legal and fundamental right of the petitioner can be said to have been violated. The learned single judge also further observed in para 7 that it is not a case of the petitioner that by the promotional policy of the technical officer in force, which includes the post of senior manager, low scale 3, which does not prescribe any ratio for filling up the vacant post of senior manager, low scale 3 by direct recruitment and promotion, and that his service conditions had been altered to his detriment. Therefore, in absence of infringement of any legal or fundamental right, the petitioner is not entitled to any relief claim in this petition. Para 6 and 7 of the learned single judge are reproduced in below. Next para. From the above, it is very clear that the plea of the petitioner is that from the above is clear that the petitioner plea is for determining a ratio in a higher post of senior manager, low, within bracket MMG scale 3, so that the plea of the petitioner is that what is the last sentence?
The plea of the petitioner is for determining the ratio in higher post of senior manager.
Ratio for promotion so as to afford a reasonable opportunity for career advancement. Though he has sought for fixing it at 50% of the total post, and sought for fixing 50% of the total post to be filled up by a promotion. On the other hand, it is the plea of the responsible authorities that the rule is silent as regards apportionment of percentage for filling up the said higher post, either by direct recruitment and the promotion. And in such event, the authorities would have the liberty, discretion to proceed to fill up the post, either by direct recruitment or by promotion, as the case may be. And in any event, the petitioner having availed the opportunity for promotion and did not apply for direct recruitment, no legal rights can be said to have been violated. As regards from the above, it is clear that there is the recruitment rule is silent. Relevant recruitment rule or survey rule is silent about the apportionment of percentage, apportion of the post to be filled up either by direct recruitment or promotion. Promotion. In our view, it would be desirable to fix the ratio of the source of appointment, either by recruitment, by direct recruitment or promotion, as per the wisdom of the employees. for the reason that first of all it would obviate any arbitrary action on the part of the employers to fix the source of to determine the source of recruitment and also enable especially the employees at the lower level to have their to ascertain their future prospects in the service. This aspect has been already dealt with by the Honorable Supreme Court in a number of cases, including in so in case number Jay Singhani so. The Honorable Supreme Court also has opined that it will be desirable.
Para 15.
Desirable that a roster system should be adopted by framing an appropriate rule for working of the quota between direct recruits and promotees, and that the roster should be maintained, indicating the order in which appointments are to be made by direct recruitment and promotion in accordance with the percentage fixed under the statutory rule for each method of recruitment. Full stop. Full stop. The said observation was made to obviate any exercise of arbitrary power, is also observed by the Honorable Supreme Court in the same case in para 14 thereof. Para 14 and 15 are reproduced here in below. Then there is another judgment.
I'll place it, ma'am. Tomorrow itself.
We have also what is that you said that in 3 other cases that ratio has been different. Was that?
No. I'll place it tomorrow morning.
No. That you said in
My lord will come to page 38, my lord.
Page 38.
Let's check.
Yes.
My lord will take agriculture.
Yes.
MMG 2 to 3, 30 posts.
Yes.
Credit is 14 posts.
Yes.
And my lord, then the next one is, my lord, that law. 2 posts.
These are for promotion.
These are for promotion. Now the direct recruitment is at page 43, my lord.
Yes. Yes.
Agriculture, my lord, is full for promotion. Full promotion.
Okay.
No agriculture put to advertisement, my lord. Then manager credit 51.
Okay. In this regard, we have also noted a submission advanced by Mr. V.K. Nair, Legislative Council, that in fact, the bank authorities had been following a very arbitrary and non-uniform policy as regards recruitment in other higher posts as well. Referring to the promotional, advertisement for promotion initiated on 5/1/2019, it has been submitted that in respect of the higher posts of MMG scale in a manager agriculture,
Senior manager agriculture.
Senior manager in MMG grade scale 3, 30 posts were advertised for to be filled up by way of promotion. Similarly, in respect of senior manager credit /CA/FA in MMG scale 3, 14 posts were advertised.
Lordship.
At the same time, for senior manager law in MMG scale 3, only 2 posts have been advertised to be filled up by way of promotion. However, while issuing the advertisement for direct recruitment, it is seen that no post had been at all advertised in respect of manager, senior manager agriculture in MMG scale 3. Similarly, in respect of credit, senior manager credit /CA/FA, as many as 26 posts have been
credit man of 51 vacancies.
Senior manager 51 vacancies have been
put for direct recruitment.
Whereas in respect of senior manager law, MMG scale 3, 55 number of vacancies have been filled up. And as per, it has been submitted by Mr. Nair that the total number of posts of senior manager low in MMG scale is 57, which is also admitted to be correct by Learned Senior Counsel for the bank authorities. Thus, what we see is that out of total 57 posts of senior manager low, 55% are sought to be filled up by our direct recruitment, whereas only 2 posts are sought to be filled up by promotion. While we cannot make any observation at this stage as to whether such a policy is such reservation, such apportionment of posts to be filled up by direct recruitment or promotion is valid or not. We would like to observe that in absence of a rules, the authorities would be liberty to change, to vary the source of recruitment, which perhaps would be avoidable in view of the observation made by the Honorable Supreme Court referred to above, as it would introduce the element of arbitrariness. Full stop. Under the circumstances, we are of the view that the bank authorities must lay down a policy by prescribing a specific quota for both direct recruitment as well as promotion, so that promotion to avoid any arbitrariness in the matter of recruitment is also observed by the Honorable Supreme Court referred to above.
Well, may I make one submission? On 23/4/21, even in before the Honorable Single Judge also, 5 posts in addition to those 2 posts were kept vacant.
Okay. Full stop.
So that post, my lord, even if it given, I come in.
Yes. Full stop. We have also noted that this court, while admitting this appeal, had directed that
5 posts of 23/4/21.
Huh?
23/4/2021.
23/4 had directed that 5 posts of
Senior Manager Law, MMS 3.
which are lying vacant shall not be filled up without leave of this court. Shall not be filled up.
Shall not be filled up.
Until further orders. Full stop. Though this court is refraining from making any, giving any direction, any specific direction to fix the, direction to fix the ratio or quota for recruitment from these 2 sources of direct promotion, keeping in consideration that only 2 posts have been already earmarked for promotion and remaining 55 are direct recruitment, till the authorities decide, till the authorities frame this rule, specify the percentage of recruitment of the direct recruitment and the promotion. The said 5 posts which have been directed not to be filled up can be considered for filling up by way of promotion.
I'm already through, madam, within the list, within that 5.
That may have a legal problem. Huh? We
No,
cannot.
madam, because only 3 or 4 posts in the direct recruitment exercise was filled up. The rest are empty. That they have admitted also. So, my lord, the promotion was made on 1/4/2019. I'm not claiming for back wages, but at least my other seniority and all things, my lord, will give me. But back wages
only while allowing this appeal, we also direct the bank authorities to consider the case of the present appellant for promotion to the higher post of
Senior Manager Law, MMS 3, with effect from 1/4/2019.
From one of the posts, 5 posts which are lying vacant, lying unfilled. In terms of the order of this court, in considering the fact that the petitioner appellant has been already found to be eligible for promotion to a higher post.
My lord, the promotions were effected on 1/4/2019. My lord. No back wages. That much, my lord, will.
Promotion will be from the date the vacancy is available.
No, no, it's for the earlier promo that 2 persons were promoted on 1/4/2019.
1/4/2019.
2019.
And the direct recruitment post were advertised on
12/2/2019.
from the date when the other other persons who were considered along with the petitioner were promoted, that is from 12.
1/4/2019.
19. With the above observation direction, the present appeal is allowed.
Much appreciated.
Supplementary list for hearing, item 33.
33. What is this? What is this?
My lord,
Zero, what is it?
my lord, we are the employees
Of?
of a department, Labor and Employment Department.
What is?
We were
what is
under the ESI. Then the affidavit was filed by the government during the course of the appeal. Because they did not file affidavit before the learned single judge.
No, what is to be done today? For hearing? For
It's-
hearing.
We are continuing, of course.
You are continuing.
Yes.
And
we are
you are pleased for what?
I'm
Higher
sorry.
pay scale, higher pay scale.
No,
Then-
this is I was under the ESI, 27 dispensaries are there. Throughout Assam, one hospital on the ESI,
How
we are
many of
pharmacists.
you were there? How
We have
many?
a pharmacy, about 5 numbers.
Five petition
Seven.
appellants.
And Kima numbers. There are about 3 numbers.
Your appointment were.
About 7. Our appointment was made in pursuant to advertisement by the Labor and Employment Department. And thereafter interview was taken place. But why I am before this honorable court, the learned single judge with great respect relied on a particular rule held under the Health and Family Welfare Department, the pharmacy rules, which at that relevant time, that rule is not applicable so far as these appellants are concerned. Because they doesn't have a rule of its own. Because 1984.
Kindly let us read the learned single order.
Yes. Judgment, your lordship will find at page 99. 99. And the operate at page 100. 100. Paragraph 3, my lord. Lordship 5.
The petitioners, so your appointment was challenged by some other petitioner.
Yes, unsuccessful.
The
They came.
petitioner qualified registered pharmacist.
Yeah.
Para 2, huh?
Yes, register were aspirant. They challenge the order whereby appointed appointed as pharmacist. ESPN under Labor and Employment Department. The appointment of the private respondent are being questioned on the ground. The advertisement not issued to enable participate interest aspirant, and since the selection was
So
confined.
there was
to-
no advertisement.
I'm sorry, there was
There
an
was no advertisement.
There was an advertisement, and it was because as well bifurcated. Labor and
No, after this, your appointment was set aside, then what happened? This post were.
then
filled up
we
again.
were appeal, the court said that we should continue. There was a.
Oh, you are continuing.
Yeah, I'm continuing. I'm continuing, and my lord, during the appeal, they did not file an affidavit before the learned single judge. Now they have filed an affidavit.
Now,
Government has filed an affidavit, my lord.
and you were appointed by which date?
We were appointed, my lord, 2000 appointment letters are there.
Please.
Yes,
Which year? you
page
were
40. In 2006, my lord.
No, say,
2006.
and you are still continuing.
No, we are continuing.
And who is the private respondent
The
here?
private respondent has not, they are not interested.
Yes, government, what do you do? Tell us.
We have filed an affidavit here.
Are you also contesting this?
No, in
Huh?
fact, not. In paragraph 4 and 6 of the affidavit, we have said that the selection was conducted on merit on the basis of an advertisement.
So if there is no, so there won't be any problem if we allow this appeal.
From our side, no.
There is no. Why is the private respondent? If they are not there, what can we do? Huh?
They are
You can't
not
wait.
interested now.
Huh?
They are not interested because I have been told that they are in some other jobs they got. 2006, today is 2023, my lord.
There is a saying, if Muhammad doesn't go to the mountain, mountain will go to the Muhammad. So shall the High Court go to the residence of these parties? Huh? Huh? If they don't know what to do. Let us read this.
Yeah. At page 99, my lord. At your lordship, at para 3.
Yes.
Para
But
three.
the appointment of the Paris one is being questioned on the ground that advertisement was not issued to enable participant interested aspirants, and since the selection process is confined only to limited candidates.
Sponsored by
Limited
the,
candidate also, you went through the limited
Yes.
employment exchange.
that the labor and
Legally,
employment was sought
question
for.
to candidate selection was made by incompetent. The two things. Number one, no advertisement. And number two, incompetent committee.
Competent.
Now, let us see what is the regarding that
Three.
powers 309 Assam pharmacist rule.
Yes.
Your appointment is a pharmacist.
My appointment is not pharmacist. It cannot be because
So,
1980.
according to you, this rule is not applicable to you.
Not applicable.
Okay, according to which rule is applicable?
Now there is no rule has been framed
At that time also.
at that time also. So that's why we have come up.
And what is the stand of the government as far as this pharmacy rule is
So
concerned?
they said also my affidavit that rule is not applicable.
In our affidavit, we have said that
Then what is applicable according to you?
No, there is no rule framed.
there is no rule.
Rule frame.
They have
By an order,
But
the committee
then
was
again,
pushed.
then come to next para. Why
Yes.
the state has not filed any counter affidavit?
That's why I pointed out before the appellate court that the affidavit has not been filed.
And
At least we should know the stand of the
yes,
government
then
without passing.
how
Now
do
there
we
is
know
an
this?
affidavit which has been filed by them.
Okay, what is the source of the affidavit?
yes.
Yes.
We filed the affidavit on 17/12.
Okay, let us see that affidavit.
Yes.
Paragraph 4 kindly be seen, man.
No. Let us see.
Affidavit,
the
affidavit.
Para-
We need to file the affidavit.
Yes, affidavit on 17/12.
1712.
What is the para number?
Para number 4. No?
There was urgent need of pharmacists. You are pharmacist.
Oh, we are farmers.
They are pharmacists under the ES Act,
Yes,
which is under the Labor Department.
Okay. This is one. Then number, what about the, so, learned single judge procedure said that this service rule notified recruitment taking once slip prescription so. And so. While the several filing no employment, that employment vacancy in ESI dispensaries was initiated through a letter whereby directly requested to find various. Although the draft was often encouraged, the window was not published and recruitment was confined candidates sponsored by the exchange.
Hello, Lalit Singh.
At the applicant of the sponsor exchange were asked, approval as appear in the parent appearance. They will go through the impugn orders subject to collision temporary appointed pharmacists. Older parents contained they were appointed through community in the what is appointed in the community handbook and even the pharmacists. Even the pharmacist rule require issuance of advertisement for direct payment does not permit appointment by limiting to. What is this pharmacist rules?
1986, my
That
lord.
was referring para
Yes.
3.
Para 3, and there is a committee which has been constituted.
Made in expense, therefore it okay, never haven't got constitution. Now, this pharmacist rule, how do you say it is not applicable? Why do you say the government?
Government, my lord, affidavit.
How
At
many?
para 10. At para 10, there is not applicable.
You are in labor welfare department.
Yes, that's why.
Okay.
That's the
New
because
department, you
actually,
labor
unless-
welfare,
learned
not health. and-
because at
Most
that
of
time
the
there was no
pharmacies were
affidavit.
in the- Under labor welfare, permanent rule governing.
There is no rule.
Because that no affidavit was filed, it was not pointed out before the learned single judge also.
Okay. And how many people were sponsored by the this
Yes, my
By
lord
the-
will
by the-
kindly see.
employment department?
Yes, employment department.
Please come to para 4 of the learned single judge. He says, and whereby the director of employment requested for notifying venue through the district
Page 63.
to invite applicant for eligible by publishing the notice in the notice board.
Page
Was it done?
63. Page 63, Mike.
Page
63 of the appeal.
63.
This is the advertisement.
This is advertisement. It was actually issued.
It was issued to a labor and employment department.
Ah.
And they wanted urgent purpose, they wanted. Whoever registered under the employment exchange, their names were
Okay.
same.
Now, how do you say that it is permissible? Urgent. That this.
Mine, it
this
is written
method of-
here.
That this method is also permissible.
Yes.
Mr. Nath told that legality. That for urgent purpose, we can restrict through the employment exchange.
In those days,
Huh? Sorry?
and through the employment exchange, several selections were done.
Correct.
But in fact, they have, here they have said that there is no rules governing their service.
Correct, that we have understood, but
Yes,
still,
yes.
you're the, at least,
In fact, annexure 1 to
it
the.
doesn't mean that you just go and stand
One
and say, okay,
judgment,
come.
I found
Annexure
one
1 to the
judgment,
affidavit. Can you see?
because one judgment of the Supreme Court. And 1987 3 SCC page 308. You just
What does it
mark
say?
it. Last paragraph, it says,
Hmm.
in the absence of a better method of recruitment,
Yeah.
we think that any restriction to employment in government department should be through a medium employment exchange doesn't often Article 14 and 16 of the Constitution.
Okay.
With this motivated judgment, they appeal so and so. Yes, I just relied. Actually, it should be through an employment exchange, but it should be an advertisement.
Hmm.
That should be. My lord will kindly see 319. 1987 3 SCC at page 319.
Yes.
Last paragraph, 4 paragraph. In the absence of a better method of recruitment, we think that any restriction that employment in government department should be through the medium of employment does not offend Article 14 and 16. With this motivated judgment, so and so is. Normally, it should be, my lord, through an advertisement. That's the way.
Now, this page 63, you have just,
Page 63.
this is also advertisement, but it's only through in
Yes,
the
correct,
employment
Correct,
exchange,
correct, correct.
not in the.
Not
Public
in,
the-
not in, no.
So those who don't know where employment exchange
is
is, they
just
will
one-
not get the opportunity.
But this was all the names, all the who is registered, all these names were sent. They also were sent. It is not that it was not sent to the private respondent. There were a number of, my lord, your lordship kindly see the advertisement. There are 10 post pharmacist, laboratory technician, one numbers at page 63.
What about the other post laboratory
Other
technician?
they're continuing. All
They're
this-
continuing.
They're continuing.
They're
All of-
continuing.
Nobody has come and challenged.
Challenge.
this. They are all continuing. These are labor and employment. No rules has been prevailed on it.
Page, page 92 of the affidavit.
The private respondent have been some notice or what? Before
Yes,
that,
sir,
they are
yes,
not
sir.
some notice, then Mr. Das, then we are in difficult
No, I
position.
think they have.
We will
been-
not proceed.
No,
There
I
must
am
have been
sure, your lordship, that how can we without hearing them?
That is what,
Yes, yes.
So we must
Yes.
first ascertain from the record. I am not
Yes.
saying that you are making any wrong statement. That only thing that we want to know whether there have been some notice or not. An affidavit of position filed by respondent for receipt of X honorable personal affairs enclosed. Affidavit has been Waklanama on behalf of respondent 2. Who is respondent number 2?
Before the court also.
Who is respondent number 2? Waklanama has been filed. Who is the respondent number 2?
Two is the private.
Private respondent.
Two is Sayeda Roshan.
Yes.
What about 1 and 3? 1 and 3, non affairs taken on. It is seen that the affairs notice were issued to respondent number 2 and 3 by resta post. The office. See, appraisal notice have been properly responded. How will respondent neither ID card involve the penal direct to first step on respondent 2 by usual court process. On 15/2/22. April and the appearance further given opposition take first step 2 and 3 by resta post. That was on 11/3/2020. Can you just ascertain whether notice have been served? Otherwise, it will be difficult.
I think your lordship, they should get the opportunity if they.
That is what you
I
see.
also feel my, that's a.
If they have not been
I
served,
will
then
check
we
it.
cannot-
We'll check that.
We'll
my-
check up.
We'll check.
We thought we are going to dispose it just now.
We'll check, your lordship can give us time, we'll check it now itself.
You check it now. If it is not served, then we have to pass order. You can step by dusty.
Yes.
Otherwise, we thought we'll dispose it of just
Yes.
now.
No, without hearing, if it is then,
Find out, you can
it will not be,
find out from the registry if the is the status.
yes, what your lordship can do one thing. We'll just find it out, we'll find it out from registry also, as your lordship indicated.
No, what Racy won't have any document except this one. Racy doesn't keep a separate register. All are along with this.
Section, medical, sign, postal journals.
You can put on 7 days, a long time back, 5. See, if the notice has been served, then the problem arises. Then we can't dispose of. If you have not taken, then we have to take dusty. You have to take dusty.
Respond number 3 is deemed to be served.
Is mentioned.
Yes,
And
in 15:2,
okay,
the
very well.
office note further reveals.
Okay, what about respondent number 1?
And however, in respect of 1, 2 and 3 by register port so and so, the office note for reveals. As said, however, in respect to respond, neither the AD nor the notice have been received. Further, no service report has also been received.
Yes.
In view of the appeal related to first step by usual to the office of learned Munsif concerning section is direct to list the matter. Not yet has been viewed the document, the matter is placed before the court. It'll take some time, because there are a lot of orders, because they're very old matters. Your lordship has, I'll just check it and let it be placed, my lord. Your lordship has heard it. Whenever it's possible and it's convenient for your lordship.
You
We'll
check
get-
it up on, let it come on Monday.
Monday.
It will be served. Otherwise.
Otherwise, your lordship,
Otherwise,
will
you
take
have to
a,
take a step.
otherwise we have to take a step.
Yes.
Without hearing the other side, it will not be proper. They will also come and again they will say
They will file another.
another repetition. So we don't want another more litigation.
Or if you then, and if they're employed somewhere, then also. notice
Because this is a-
to begin.
It's very old matter.
Then also they are entitled to getting.
Only, there is only technical problem.
Yes.
Otherwise, at this stage, we don't want to
I
interfere.
think they will also, I just inquired. I have not seen the record. They are into some other job they got.
No, but that, then also you cannot deny them.
No, that cannot be. I'm just informing
Otherwise, they have got every right to appear for the court.
That is why they also.
Unless the notice has been served or they are not appearing, that's a different thing altogether. We have to, because this is an old case, there are a lot of orders are there. Lordship will be sitting and we have to. Let me check the records. We'll check the records and let this matter come on Monday. Your Lordship has heard. Is only remaining part of a notice. That part.
Yes. You check it up Monday,
Yes.
Monday, Tuesday, whenever you want.
So any Monday, let it be on Monday.
Monday.
So your Lordship has heard only about notice part.
Yes,
If you see that notice has not been served,
then
then is there is a provision also deemed also. So we'll check that also.
Okay. Monday.
We see. They come on Monday. Deeply operate.
Timing item 1 to 5.
1 to 5. What is this? 1 to 5? What is this? Keep this. Oh, that. What is this matter?
This is regarding the appeal by the APDCL.
Oh. We are really sticking to this money. It's not your money, mister.
No, just
You
one
want
aspect.
to enrich somebody else's money.
Just one aspect of the matter, Your Lordship. I'll leave it at that, Your Lordship. Otherwise, we have already filed our written arguments also,
Yes.
along with a list of this. Just one aspect of the matter.
Yes, yes.
The tender mandates, Your Lordship.
Let us see the tender.
Yes, Your Lordship.
Well, that is what more important, yes.
It starts at page number 41.
31.
41.
This is the tender notice?
This is the tender document.
This is the tender. Then it was.
Just
total-
one clause, Your Lordship.
Yes.
Two
yes.
clauses, in fact. One at page number 63.
63.
Yes, Your Lordship.
Yes.
12.6.
Yes.
The bid security may be forfeited. One is not relevant. B, in the case of a successful bidder, if the bidder fails within the specified time limit to sign the contract agreement in accordance with the bidding document, to furnish the required performance securities in accordance with the bidding document. This time limit, Your Lordship, will have at page number 69, Your Lordship.
If the bidder, which one is applicable according to you?
Lordship.
12.6 A or B? Which one is
B, Your Lordship.
B.
B.
The bid security may be forfeited in the case of a successful bidder.
Yes, sir.
If the bidder fails within the specific time to sign the contract agreement in accordance with the bidding
Bidding
document.
document. So the
Now-
specific time limit, Your Lordship,
Yes,
we'll find at page number 69, Your Lordship.
page number 69. To sign the contract in accordance with bidding documents, page 69, yes.
69.
Yes,
Clause 22.6,
22.6.
Lordship.
Yes,
Contract agreement documentation.
yes.
The sequence of contract agreement documentation is given here under letter of award by employer and its unconditional acceptance by the bidder within 7 working days from the date of issuance of letter of award. So the
Letter of award by employer.
and its
Contract
unconditional
agreement section
acceptance.
you may join. Letter of award by employer and unconditional acceptance by the bidder within 7 working days from the date of issuance.
So within 7 working days, they have to tender unconditional acceptance.
Hmm.
Now the letter of award, Your Lordship, will have at page number 188, Your Lordship.
188.
Yes, Your Lordship.
Yes.
Yes. Now this letter of award, Your Lordship, otherwise it is completely in accordance with the tender document, except for the payment schedule, Your Lordship, where admittedly there has been a change. There is a deviation from the contract document.
Page.
The payment schedule, Your Lordship, will have in the additional affidavit that we filed. It was inadvertently not enclosed, but there is a deviation, Your Lordship. It is there in the-
Then deviation is from your side.
from our side.
Then
In the
matter
payment
ends
schedule.
there, matter ends there, matter ends
Just
there.
one aspect. Your
What
Lordship. One aspect, I'll leave it at that, Your Lordship.
What leave?
The email that they sent.
You are
so-
the one who said first change.
One aspect, Your Lordship. Just one aspect, and I'll leave it at that. I won't bother Your Lordships again with this.
What is that? Tell us.
Page number 191, Your Lordship.
191, yes.
Yes, Your Lordship.
Whose email is this?
This is an email written by them on 17th. So 2 days before, on 19th, the 7-day period would have expired. Their grievances, Your Lordship, will have tender number grievance number 1 is that the time period should be increased. Grievance number 2 is that the lithium cell.
Okay, they also made some different
Yes.
demand.
Now-
Now question is, this, how do you say that you have the change in the time schedule in
Yeah,
188? How do
Yes,
you
Your
find that?
Lordship. Lordship, the schedule which is next to the letter of award, that is there in the additional affidavit. And
That
the
page number, that is that page number? Do you have that?
additional affidavit, Your Lordship, which we have filed on 31/8,
Ah,
page number 9, Your Lordship, of that additional affidavit.
Page number 9.
Yes, this is the changed
Okay,
terms.
change, what is that, which have brought change, what change you have brought? Term
That
and-
initially 60% of the amount was to be paid to them immediately on starting the work.
And here by.
Here we have said that on actual completion of 60%, will pay you 60%.
Okay, what is that, what is that?
Lordship, at page number 9 of the additional affidavit,
Ah.
at the bottom of the page,
Is the project completion, the
Note.
release of sales will be based on the physical. And this change was, and earlier is.
earlier it was that 60%
Where- where is
immediately on
it?
starting of
Where
the
where
work.
do you find that?
Lordship, that is at
Page 155?
155, yes, Your Lordship, page 155.
I think that let us
Just-
end this.
just
And
one
let us
aspect, Your
end
Lordship.
this. You have too much voluminous pages.
Just
Now-
one aspect, this I want, just this one aspect, since their primary grievance, Your Lordship, was regarding the completion date and the lithium cell. Now, after completion of the 7-day period, only they have said that, okay, we are willing to complete the work if you keep the payment schedule intact. Now, once the tender mandates that unconditional acceptance has to be rendered within 7 days, Your Lordship. So after that, Your Lordship, they have said, after the expiry of the 7-day period, they have said that, okay, we are willing to forego the other 2 clauses only if you accept the payment schedule. If you revert the payment schedule back to the, so that issue was not considered, Your Lordship.
How does it matter now? There will be so many.
Because otherwise, Your Lordship, this is a case, Your Lordship, where they have a efficacious alternative remedy, Your Lordship. Now, if the violation by this, because this is a action taken by the state in its commercial capacity, Your Lordship. Now, if the violation is such that, Your Lordship, it offends the.
But correct, they may also responsible for violation, but you also started a violation.
Then, Your Lordship, perhaps that the inter se claims of the parties should be
No, we are not going
examined
to,
by us.
we are not going to enter into that.
Just that
It must be
aspect.
a clear case.
If you wanted to examine that, you should have referred it for dispute resolution.
Because, Your Lordship, the dispute resolution mechanism, what had happened, they filed the writ petition before this court. And during the pendency, initially, prima facie, the main challenge was to the new tender process. There was no interim order. We went ahead with the tender and forfeited the bank guarantee. So the challenge to the new fresh tender process.
Even you have not, your work has not suffered.
What happened was that because of the expenses involved and the hardships that we had to face in initiating a fresh tender process, and the new tenderer has completed it with the same terms, Your Lordship. These terms that they found it difficult, the other parties.
So your work has been executed without any.
Now it has been executed, but we faced some problems, Your Lordship, because of delay we had to face, Your Lordship. So that is the only aspect. If they have a claim and we.
True, they may be also responsible, but the question is that you should be also without any blame. You must be also blameless. The moment you have committed some mistake, then they will try to latch on that. And we are only on pure terms of a contract.
Yes, only on pure terms.
Change a contract.
Only on pure terms of a contract, Your Lordship.
Therefore, whether they had done or not, prejudice or not.
So perhaps this issue should be left to a court where you can lead evidence.
But then you can invoke this only when this completed, no? See, because they said that we couldn't have done because you have changed the terms and contract.
Then what they initially said, Your Lordship, I'll just take Your Lordship to the email correspondence. At page number 191, on 17, they said, number 1, we have a difficulty with the completion date. Number 2, we have a difficulty with the type of cells to be used. Number 3, we have a difficulty with the payment schedule. Then after expiry of the period.
Payment schedule, because I say difficult because of change, no?
The payment schedule part, Lordship, payment schedule part we have changed.
Correct. They have raised any objection in that?
Payment schedule part. Payment schedule part, they have raised an objection.
Where is it?
At page number 191 itself. 191 itself. In their email, the first objection is regarding the completion date.
That is a valid ground.
But the other 2, Your Lordship.
Maybe they also like, they also want to take advantage of it.
Lordship, my only argument.
change you made after issuance of the letter of award.
Along with the letter of award.
Along with
Without
the-
informing them.
No, it was not
So
informed.
that is
So
the matter.
my only submission is.
All their contract matters.
Yes, these are contract matters, Your Lordship. Perhaps they should go to the civil court where we can all lead evidence, Your Lordship, and settle our because
No, we can't ask you, allow you to hold his money and go. If you want to recover, you recover from him. Any inconvenience caused, you file a suit for damage against him. Because of you, we have to undertake so much.
that may be reflected by
Then
Your
you can
Lordship.
recover from
Because
that.
otherwise-
It is up to you, if law permits.
Because Your Lordship, once there is a finding, Your Lordship, perhaps even the
Why is
suit.
the line a single judge opinion? Why is the line a single judge?
The order starts at page number 1. It starts at 247, Your Lordship.
Okay, we have closed this, it will be.
May I just make one final submission, Your Lordship? Then Lordship may give us the liberty, if Your Lordship is inclined to approach the civil court, and the findings of the learned single judge will not operate as res judicata if we file a suit, Your Lordship, because otherwise
Okay.
we'll be severely handicapped, Your Lordship.
Okay.
Not sure.
You are also created a problem for him. So
Take a
whatever
chance
that,
also.
we cannot stop him, no, we can't do anything.
Yes,
He's up to.
We may have a
Whatever
chance
is
to take a counter claim.
Whatever, if law permits.
Only
Law-
basic-
We are not asking that you go and file. And then if law permits, if they have a right to.
Yes.
Register before appropriate.
But only
they
these
will be
findings,
liberty
yes,
to-
Your Lordship.
Yes.
Malan has seen page 63. Just for-
Oh, Mr.
Yes.
We'll go impose force on you on the bar, advocate on the respondent side after allowing this appeal. Huh?
Obliged.
Huh? 1 to 5, same, na?
Yes.
Okay, why 1 to 5?
Five packages, five packages.
Huh?
Five
5
packages.
different packages.
How much you are going to distribute to the lawyer fund?
Malan, I am claiming for interest also, Malan. If that comes, Malan, definitely. Otherwise, my principal amount is blocked.
Timing item 14 and 15.
Deeply obliged.
14 and 15. Okay. Contempt.
May I
What
take
happened?
them,
14, 15? 14, 15 contempt. Yes. Bukul Malakar. Yes, what is this? Request of-
I'm entitled.
Alia, yes, 2 weeks to file affidavit. Yes, are you filing affidavit? Have you filed?
Lots of we have filed.
You have filed.
Yes, lots.
What is the direction of the court?
My lord, direction of the court is to give minimum. pay
Minimum
scale.
pay scale, master roll.
Yes, my lord.
And you have not given, why?
Given lordship. That
You
is
have
what I
given?
am trying to understand lordship. What is his actual
No, my
given?
lord, they have not
Lordship,
given.
in fact, it was a judgment lordship in which he was not a party. It was a judgment in Ram Lord. So if others are not before your lord.
My lord,
No, in the contempt, have you filed an affidavit?
Yes, lordship, 475
Where is the affidavit? We don't have the affidavit. We have before
on
us.
8/8 to 2022
Huh?
lordship.
Okay. Mr.
there is a
Response number 1 on the
Mr. Nayak, Learned Counsel appearing for the respondent, submits that the respondent has filed an affidavit. However, the same is not before us. Let it be, let the affidavit filed respondent
Yes.
placed on record, no matter,
Yes.
instead of 2 weeks.
He has received copy also.
You have received
Lordship
copy.
will,
But we don't have it here.
Lordship.
That is, next, item number?
Yes, no problem.
Okay,
Bola is to be replaced by Pawan Potabu.
okay, let it come up. Yes, call out, what is this?
Daily list for motion item 1.
Yes, Regina Khatun.
Yes, my lord.
Yes, what is this? Sir, have you served notice?
Yes, we have served notice and additional affidavit also filed to that.
Yes, who is appearing for the For the respondent, no response. Bora, somebody present in how it is. Keeping giving liberty to serve notice on respondents. Respondent, who is appearing for respondent?
We have served a notice, my lord, pursuant to the
How-
honorable court order, my
How
lord,
do we,
and that has been brought by the additional affidavit, my lord.
yeah, why have you mentioned they have served notice? Why have you stated we have?
Lordship, in
Who
my
is the
additional
appear- who
affidavit,
is-
my lord, lordship will find the forwarding.
Notice.
Annexure 1 page 21. And
Deputy
annexure
Commissioner.
2. Yes, my lord, before the deputy commissioner as well as additional deputy commissioner.
Yes, government advocate, Mr. Chisti, we are not asking you to appear, but see, if they don't appear, we have to ask for personal attendance.
Yeah,
appearance.
whether service is complete or not in this.
No, I have brought on record additional affidavit. By
Yes, see.
additional affidavit. Okay, before the deputy commissioner and additional
Deputy
commissioner.
commissioner, we
Come, come.
the government lordships. I am for the education department only.
Correct. Anybody for government, just find out, otherwise, see, we don't want to pass this order, otherwise they have to appear in person.
Yeah.
Huh?
Government.
For nothing. If notice has been served and he doesn't appear,
That is true, yes.
so then, yes, anyone from the government side,
Yes, sir.
deputy commissioner, please tell them.
Government side.
Is he Kamal Kumar Baisho, is he still in service or retired?
He has retired, my
He
lord.
is retired, that is why,
He is
you know, the
retired.
one problem, no, one.
That is long back, my lord, before that,
But we have filed his petition only.
we have submitted this forwarding before the present deputy commissioner. She's in service, my lord.
Then you have to make her a party, I don't know who that. You must, otherwise it will not serve the purpose, no, because person who is retired. Huh? Can you include those newly, at least
Implement,
person who,
right?
yes, at least who is serving,
Lordship,
Otherwise-
pursuant to the honorable court order, my lord, we have
correct, but then. if you-
submitted this for.
Correct, but then. It's up to you, see, otherwise it will be like a shuttlecock from here there, unless you take steps.
Yes, my lord, implement.
Okay, you implement at least those who are here, you can.
Yeah, I may be allowed to file an IO by pleading the.
Petition is permitted to file application for impleading the official concern officer, current official, current concern. Yes, next.
Yes, weeks. Item number 2 is also same, my lord.
Same order, na? Okay, then.
Yes, my lord.
Item number 3.
What is item number?
I don't know, 3 losses and every on behalf of the respondent of 1 losses.
Have you
No,
filed your
lordship,
affidavit?
before lordship, only sole respondent.
Yes,
But the direction that the petitioner obtained was page 23, paragraph 5 lordship.
yes,
It, in this regarding the constitution of SMTC lordship, now the deputy commissioner here the jurisdiction lordship. The inspector could only forward the names of the president lordships. And the notification that was mentioned in the judgment lordship date 2016. Subsequently, there's another notification lordship 27 October 20, that was not not mentioned in this order. So I think he should have filed a review lordship and gotten this order in terms of this notification that is 27
Then
October.
file an
2017.
affidavit, will clarify
Yes,
the
sir.
factual aspect, huh? File it, huh? Mr. Chisti, appearing for the respondent will file an affidavit, verifying the position. You file it?
Yes, sir.
Oh, what do you say?
My lord, yes.
Is it correct? Then there is no point. Ultimately,
point
what,
of
you want to
continuing,
withdraw and file what? Up to you.
My lord, let them file the affidavit. If requires, we will file reply.
Next.
Item 4.
It's 2 weeks.
Turun. Yes, yes.
In this, it will require 4 more weeks time to comply with it.
Huh?
Process has already been done.
Okay, Mr. Lana Council for the second summons that he may be granted 4 weeks time to comply with the court's order in view of the vote, the present. Maybe listed after and hard of the Mr. Yes, next,
Item 5.
I also am seeking for 4 weeks time, my lord.
same for compliance
For
or?
compliance, for
Okay,
compliance.
Same,
Awaiting approval from the.
okay.
Item 6.
6 lordships, the present, the respondent is the earlier director of secondary education. So far as he is concerned, he has already complied and he has forwarded that he sent a proposal to the commissioner secretary for expect or retention and approval of the permanent retention of the post. Now the secretary is not a party in this contemplation, and this person has already been transferred 1.5 years back.
Did the secretary? Huh?
So he has done his part, Lordship.
Okay, no problem. You implement the secretary.
My lord, kindly give me a copy of the, let him furnish a copy of the order of the, my lord.
Yes, this is a proposal. And
Mr. Mr. Ram Shakil Mr. She submits that the concerned director has done his.
earlier
part.
director, Lordship.
Huh? Earlier director had done his part by recommending payment, huh?
Sending a proposal, Lordship,
Sending the proposal
for retention and normalization of
for
the post of the
retention of the post
and
the
normalization.
normalization
Yes.
as per communication at 3/2020 to the commissioner, secretary to governor. In that view of the matter.
The context will be closed, Lordship. This
No, 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 my lord, I will include the commissioner.
In view of the above, Mr. Saikia submits that he may be permitted to implement the concerned commissioner secretary.
My lord.
And so far as this present respondent, that should be closed, Lordship.
Hmm?
Because he is no more holding this bill.
No, my lord, I will
He is
go to
already
this order.
transferred 1.5 years back, Lordship.
Anyway, we'll see that.
Yes.
Then present director have to be implemented also, Lordship.
We will see that. Only one.
Obliged.
Yes, next item number.
Item 7.
Chandra Mohan, yes.
My lord.
Yes, sir.
Director to receive instruction whether compact.
That we have not received, Lordship. So we need some more time in this case, Lordship.
At least after 3 weeks.
After 3
Whenever
weeks.
Mr. Chisti to apprise this court about the compliance of this court order.
Yes, my lord.
Item number 8.
Yes, what is
My
this?
lord, this matter may be disposed of.
Okay, Han Mr. Lanekar, who submitted the matter can be disclosed in terms of order, in view of the order passed by so. What is the order? In view of the passing so, in view of the submission where the present petition is closed. Yes.
Obliged.
Item number 9.
Devamali,
May I plead your lordship?
Yes.
Lordship, kindly make a pass about 40 days.
for the
English
day,
council
right?
is not well, lordship.
Huh?
English council is not well.
But you are there,
She is not instructed me.
you are not instructed, list the matter for to figure is in a minute petition shall find additional opinion matter. Okay. On the para miss,
In Golita,
the matter will list after 2 weeks. Yes, next.
obliged.
Item 10.
Item 10, yes. Ismail, anybody present? State Election Commission, yes, madam, yes.
Yes, lordship.
Notice, resta post with AD. Yes, next. Next step by resta post, yes.
Item 11.
Lordship, we have complied with the order.
May I please your lordship?
Complied.
Yes.
Give a copy.
Yeah, or 9 extra. My lord.
No
please-
problem. Are you if satisfied? You comply?
Now he have to challenge this order, Lordship. Because the state scrutiny committee didn't recommend the name of the petitioner for consideration. According his case was rejected, Lordship.
And Mr. Lane Council for the petition house, Lane Council, Mr. Chichi, who submits that the order of this court has been complied by taking necessary decision
By the order dated 18 January 2023.
By rejecting his claim for
Provincial election, Lordship.
provincial
Provincial
election.
election, Lordship.
However, according to the present is closed with liberty the petitioner to challenge the said rejection order if so advised. Yes, next.
I am for
Obliged.
board respondent, Lordship.
Huh?
I am for board respondent, Lordship.
Have Mr. Board respondent, board respondent. Yes, next.
Board-
Item 12.
Dilip Das,
Lordship, petitioner is a physically handicapped person. And-
For a time. Mr.
you want what?
Lordship, in this particular case, Lordship has already asked them that physically handicapped certificate to be produced. Lordship has called for the record of earlier proceeding. And he was lastly medically examined by the medical board of medical college.
For what?
And
This for what purpose?
Lordship, petitioner have to be promoted to the post, next higher post. And that was not considered only ground that they want to medically examine the petitioner again and again. Lastly, he was examined by the medical board. Guwahati Medical Board. On medical board has also given the same certificate. Now they want again examination by district level board. I have annexed this certificate issued by the.
So, do you know this coming matters?
Yes, Mr. Nath, what is this? Again and again and again and again.
Give me, they are giving me the instruction on the affidavit filed by them by tomorrow. Kindly give me time till
Tuesday or Wednesday, I'll file a reply.
Lordship, kindly see, Lordship.
Without fail.
Lordship will kindly
Okay,
see.
list the matter on Wednesday, by which time respondent may file the affidavit without fail, failing which the matter will be taken up without the
Yes.
affidavit.
Lordship.
Matter will be taken without affidavit
Lordship.
on Wednesday.
Dispute is, Lordship, kindly see, dispute is regarding the Lordship disability certificate.
Anyway, let them.
Already government has given a list.
Will dispose on that day, and attempt will
Over-
be made to
over
dispose of
telephone?
this, and attempt will be made to dispose the
Yes.
case on that day.
No.
On that day.
Item 13.
It is for compliance, Lordship.
On it, whatever, will. On that day, an appropriate order will be passed.
Compliance.
Yes, item number.
13. My lord, here, honorable court's order, page 24.
Notice has been issued. Yes, Mr. Chisti, anything?
Twen-
Yes, do you have any idea?
No, Lordship.
Notice, notice, rest of post with ready.
I need
3
one
weeks.
more time, Lordship.
3 weeks.
Yeah, 3
Next step, you take, yes,
Order implement of party. Item number 14.
yes. What implement?
I has been filed for implement of new director,
Mr.
pension
Sankar, the
hospital.
application file implementing the new director, namely Swank in a condemned petition is pending with the price allowed. So maybe a respondent number.
As per number 2, my lord.
Petitioner takes a newly responded by rest of post with 80 return with 3 weeks. 6 weeks.
Obliged, my lord.
For admission, item 15. Arbitration.
Yeah, please, Your Lordship. Lordship, I'm appearing for the respondent on behalf of Mr. Ajutta. Lordship, we were awaiting instruction and only today we have received the instruction. Lordship.
Okay, hard Mr.
Yeah,
what is your
why
name?
about Bhuiya?
Huh?
Why about Bhuiya?
This after 3 weeks, to file necessary affidavit. Yes, next.
Obliged.
Yes,
Item 16.
yes, anybody for 16? Yes, Mr. Hussain, what is
My lord,
this?
in this case, the respondent is yet to file the counter affidavit.
Yes, who is our respondent?
Railway, my lord, railway.
Railways. What happened today? Railway is not turn up. All will cancel. Huh?
Yes.
Not a single railway is there. What to do? Yes, Mr.
Affidavit has not been
Doctor.
filed by them.
Huh?
Affidavit has not been filed by them.
Why they have a file? Well, what is that? What is it? On what basis you are claiming? Is it that is it hit by that decision referred to larger bench? Anything I didn't know.
No.
On what basis you are claiming arbitration?
My lord, they
Why-
failed to
why is
appoint the
why-
arbitrator,
why
my
is
lord.
Mr. Railway? Please call anybody. AK Doctor, he's not here or what? Huh? But then, how about just the extra court is no responsible for the respondent? On what basis you are claiming reference arbitrator?
Well-
Page
Page number, my lord, 95.
95. No, this is your letter. But what is that clause? Arbitration.
Close, my lord. Page number, my lord. Forty-one, my lord. And it starts from page 40, my lord. Clause number 63. Then 64 is the arbitration clause, my lord.
Page 40.
Yes. Matter finally determined by the railway. Thereafter, my lord, next page,
No.
clause 64,
No. Page, how much page number?
page number 41, my lord.
51. Where is it by arbitration?
Demand of arbitration, my lord.
Para number.
64-1, Roman 1,
Huh? 64, there is nothing here.
page 41.
No, you are, I don't know, your page 41, this is arbitration 28. Is it item number?
Arbitration number 28, my lord.
16.
16, 20 or 22. Pradeep Chaudhary. Huh?
Yes, Pradeep Chaudhary.
But page number?
Page number 41, my lord.
I don't know that page 41. Page 41 is close 18, 19, 20. Where is
My
it?
lord, agreement starts from page 17, my lord. Page 17, my lord.
And the page
Page 17.
and your agreement.
This is the annexure 2, my lord.
I don't know.
Hindi version is at page 16 and English from
There is nothing of Hindi or Hindi version here. I don't understand.
Annexure 2, my lord.
I can't find it. Page 40.
My lord, Annexure 2 is there, my lord.
Don't go by annexure 2. I don't know.
Page 41, my lord.
Yes, Mr. You want to file affidavit or no?
Sorry, my lord.
No. Do you want to file affidavit or no?
Yes, my lord.
You filed, how long will it take?
Fifth time maybe.
Huh?
Fifth, my lord.
Mr. Filing. Yes, next.
Item 17 for orders.
DN Sharma, what is this?
My lord, here the arbitrator may be appointed, my lord.
But we have filed the affidavit objecting appointment. In fact, petitioner approached the Institute of Engineers in the year 2019. They have intimated the petitioner that you deposit the process fee. From 2019 till 23, they have delayed the matter.
Let's take it up some other day.
Kindly come back to paragraph.
We'll some other day then.
Look.
We have to pass a speaking order here. Since you're objecting, we have to pass a speaking order.
Yes, my lord.
He's objecting.
Yes. Objecting by my lord, they failed to appoint the arbitrator because the clause says with the mutual consent, both the party can agree to appoint the sole arbitrator. Now, after failure, they are objecting. Whether they don't want to.
But they say you have come for 3 years.
Yes.
3 years, my lord, because in 2019, my lord, the Institute of Engineers, my lord, this letter was issued by them. Then 34
Who has invoked Institute of Engineering? Who has invoked?
My lord, the clause says that if the both parties do not agree for the appointment of sole arbitrator, then the Institute of Engineers will be requested for the appointment of arbitrator, my lord. Clause is not saying anything about payment, my lord. Now they are demanding the payment. They failed to appoint the arbitrator, but the Institute of Engineers demanding the payment from us, my lord. Then we have to pay the arbitration fees also to the arbitrators.
They said it is processing fee, page 103.
Now, your lordship may kindly come to page 48, my lord.
Then we'll take it some other day.
Yes.
The time is over. We'll take it up. Yes, next.
Item 18.
Review. What is the review? Yes, Mr. Khatane, what review you want?
Review referred by the state, my lord. I'm seeking
Again,
review of the order dated, my lord.
Your review shall take, you are appealing?
Yes, Lordship, for the repetition.
Repetitioner.
The only ground is that affidavit in opposition was not filed. This is the basic ground for which they are filing. And there is a
Because of that, my lord, we could not brought two vital documents.
And what is the direction for the land single thing?
informal court has
The
passed an
direction
order.
was pleased to set aside the imperial order dated 15/5/2018. Page, my lord,
48.
47, it starts from 47, my lord.
File affidavit.
Yes, my lord.
If you don't file, what can be done?
Yes, Lord. What is the error apparent on the face of?
No, my lord, we could not brought two vital documents on record, my lord. That is the ground, my lord.
You file an appeal.
And where is that error? There is no error apparent on the face of the record.
My lord, kindly come to page 14, my lord. This is the document on the basis of which, my lord, was pleased to interfere with the impugn order, my lord. Page 14.
1/4.
1/4, my lord. May I read, my lord?
Yes.
In inviting a reference to the letter and subject cited above, I am directed to state that the matter of correction of date of birth in respect of Arun Chandra Soikia has been examined in this department. Now you are requested kindly to correct the date of birth of the incumbent as per certificate provided by the Secretary Board of Secondary Education with the intimation to this department. So there was a direction to correct the date of birth, my lord. On the basis of this document, my lord was pleased to interfere with the impugn order. But subsequently, this is a letter issued on 10th May 2018. On 10th July 2019, my lord, there is an office order, my lord. The government instruction issued from Elementary Education Department by letter number so and so dated 10/5/2018 in respect of the matter of correction of date of birth of so and so, so and so, so and so is hereby cancelled. So this letter was cancelled, my lord. That fact we could not brought into the record, my lord, during the proceeding, my lord. Subsequently, in 16 also, my lord, it was informed to the director of elementary education.
Mr. Khatane, also Mr.
SP Chaudhary,
who appears for the respondent, read petitioner. Matter will be released again after so for further consideration. He is Nick.
Oblige.
Item number 19.
I have for what?
Not sure. I have for appointment of substitute arbitrator. Earlier arbitrator has
Any objection?
No, no.
Or Mr. Lane counsel thinking that the present application is filed for appointment of secretary arbitrator in terms of section. There is a provision also.
Section Lordship, we have filed an application under section 15(2), read with section 11(6).
For appointment of fresh arbitrator, is the earlier arbitrator appointed, namely so-and-so, namely.
Named Minmoy Kumar Bhattacharya. He has been appointed as president, consumer dispute.
No, earlier was Roktalal, no.
Roktalal Das.
Roktalal Das.
Appointed as
He have been appointed as,
president, district consumer from Jorhat.
because of which he is not able to take up the arbitration matter. Mr.
BP Board.
Also has no objection to the appointment of another arbitrator in view of the approach in of the earlier arbitrator. Accordingly, whom do you want?
Minmoy Kumar Bhattacharya, Lordship, district.
When the court proceeds to appoint Mr. Minmoy Bhattacharya as an arbitrator to settle the dispute between the parties. Copy will be furnished to- Sorry. Is that